Well, good morning, all.
Good morning, Chair.
Yes. Today being the 8th of May, we have now recommenced where we left off the last time that we were here. And my understanding of the matter is the witness is to continue. But before we start, may I just say, well, it's good to see all of you again, and we will carry on where we were the last time. I think the evidence leader have a few questions before she completes her evidence with you. So let me say welcome, and let's begin. Thank you.
Thank you, Chair. Maybe for the sake of, may the witness please be warned that she's still under oath.
Yeah, I must remind you that you are still under oath.
Yes, Chair.
You understand that?
Yes, I do.
Yes. Thank you.
Thank you, Chair. Ms. Ngoye, I want to just take you back to your contract of employment. Now, you testified previously that you had been appointed as the Process Group Executive Legal Risk and Compliance. Is that correct?
That's correct, Chair.
And that this was effective from 1 September 2014.
That's correct, Chair.
How did this, your transfer from the Intersite Assets Investments to Group Executive Legal Risk and Compliance, how did that come about?
Chair, what I understood is that the group board, is this is sounding a bit echoey? Yeah. Is it?
Well, let's try again. Put the question again and let's see if we can answer without echo.
Thank you, Chair. The echo is still there, but okay. How did your transfer come about from Group Executive from Intersite Asset Investments to Group Executive Legal Risk and Compliance? How did that transfer come about?
Chair, what I understood is that the group board, am I audible?
It looks like we still have the same problem. There's a massive echo now.
Yeah.
I don't know if anybody can do anything about it. Who all is having difficulty hearing? I'm having difficulty. Judge Mashidi, what's you? Yeah.
It's continuing.
Okay. It looks like we may continue then. You've put the question. We're talking about your transfer from investments to legal. If you can
Yes,
just
Chair.
explain how did that occur?
Chair, what I was saying is that I understood.
I think we will stand down and let's see if we can sort this out.
Okay.
It really is getting worse. Well, let's try again.
Thank you, Chair. Ms. Ngoye, the question to you was, how did your transfer from Intersite Asset Investments to Prasa Group Executive Legal Risk and Compliance, how did that come about?
Chair, I was trying to explain that what I understood was the group board, which is the PRASA board, had resolved to restructure some of the executive positions within the organization. You will recall, Chair, part of my evidence was that Intersite Asset Investments, where I was a CEO at the time, was a wholly owned subsidiary of PRASA. So an instruction came from the group board to the Intersite board requesting that I be transferred laterally as a result of the group's restructure to occupy the position of Group Executive Legal Risk and Compliance and to build up the legal function. That's how the transfer came about, and the Intersite board also resolved to let me go and transfer on a lateral basis.
Thank you. And did you have sight of the documents, the resolution of the board that made this transfer? Did you have sight of the resolutions?
I've seen the resolutions, Chair.
I'm going to refer you now to volume 21. I want to refer you to page 24 of that volume 21, page 24.
I've got it, Chair.
May I proceed? May I proceed? Thank you, Chair. Volume 21, page 24. Have you ever had sight of this document? It is headed as the resolution of the Board of Directors of Intersite. It is dated the 11th of August, 2014. Have you had sight of this document?
Yes, I have, Chair.
And is this the resolutions that you are speaking about?
Yes, this is the Intersite board resolution, Chair.
Okay. And based on that, this resolution, it was approved that you be transferred based on this resolution.
That's correct, Chair.
Thank you. I'm now going to refer you to volume 24. It's on page 66. Do you have the documents before
I
you?
do have it in front of me, Chair.
Thank you. Ms. Ngoye, this document is headed as letter from the acting group chief executive officer of PRASA to yourself, and it is dated 29 January 21. Under the letterhead of PRASA, it is written Ms. Martha Ratslane.
Sorry, Chair, can I just correct? I'm looking at the right document. This one is dated 22nd August, 2014.
Sorry, it's 22nd August 2014 is under the signature of,
Yes.
sorry, the heading on top is written dated 29 January. That's a mistake. The actual letter from Mr. Montana is dated 22 August 2014.
That's correct, Chair.
Yes, sorry, apologies. And it's the surname that is can you explain that, is it, I don't know whether it would be a surname or a name.
It's Ratsiani, Chair. That was my
Ratsiani.
marriage surname.
Okay,
Yeah.
okay, so that, did you receive this letter?
Yes, I did, Chair.
Okay. And I want to, onto the next page, on page 67, you accordingly signed that you are accepting the transfer.
That's correct, Chair.
Now, Ms. Ngoye, at the place or near where you signed, there is a handwritten note. Did you make that writing?
Yes, that is my writing, Chair.
Can you please read it out for the purposes of the tribunal as to what did you write there?
It says, on the basis that this is a lateral transfer, I do, however, accept that I'm transferred but not laterally. I had discussed my salary review with the GCEO group, which is the group CEO, and have indicated same to him. It's got my signature at the bottom.
Were you then concerned, were there concerns in regards to this transfer?
Well, it was only in relation to my salary.
Okay. Now, Ms. Ngoye, after you occupied this position of PRASA Group Executive Legal Risk and Compliance, did you sign a contract?
No, Chair, when I got to group legal, there was no contract ready for me to sign when I arrived. In fact, I inquired about it to say, where is the contract? And I'd like to see what the role profile is saying, because at the time of my transfer, the position that had been occupied by my previous, what do you call her, the person before me, she only occupied legal and compliance. So my role was extended to legal risk and compliance, and this is one of the first issues I inquired about, because the position, was no longer the same as what had existed before I occupied. So naturally, I inquired to say, can I have this? I have to sign this. But Chair, I'm not the first person, and the issues at PRASA when it comes to things like this, I never organized, Chair. In fact, at one point, I was expected to put together my own profile, as to what the job would entail. And I said I couldn't. I said that's a role between, obviously, the group CEO and the head of HR. They ought to have known what it is that they wanted me to do. So it never happened, and I had meetings with Mr. Montana about this, and he was going to fix it. We never got around to doing it. So I basically continued waiting for this particular contract that was specific to the group executive legal risk and compliance to be finalized.
To date, Ms. Ngoye, do you have any contract with PRASA in regards to this position of group executive legal risk and compliance to date?
No, there's never been a contract.
Okay. And
Before we move on, you say there's never been a contract.
For me, Chair.
No, well, I mean, there was no written contract.
There was no written contract. Oh, yes, I understand that. Yes,
Yes.
Chair, I understand what you're getting at. There's no written contract which I signed.
Yes.
But, in terms of...
You understood what your duties were.
That's it, Chair, I did.
And would you say everybody else would have understood that as well?
Yes, Chair, everybody else would have understood.
Yes, thank you.
Thanks for that clarity, Chair.
And from the evidence that you had given in February 2023, this year, earlier on, there was a reference to the delegation of authority. Do you remember that?
I do, Chair.
Was this the guiding document used by yourself?
It was one of, yes, it was a guiding document that, we used as executives.
Okay. While you were at PRASA and Judge Makhubele was also at PRASA, was there any stage where Judge Makhubele questioned you or questioned anyone or yourself in regards to the delegation of authority powers that you were relying on?
Well, she didn't ask me and question me, Chair. The first time I got to hear that I needed, the chairperson wanted to see a copy of my contract was around March of the following year, when we were dealing with the CIA matter and we were going to court. Mr. Kramat Molepo indicated to me that one of the issues that the chairperson had a problem with was my contract, and she wanted to see it. That was the first time that I had been requested of a copy of the contract.
Did you ever engage with Judge Makhubele on that issue of you not having a written contract?
No, Chair, I never engaged.
Now, there is several documents that have been filed as part of the trial bundle, and regarding one of the matters was with regards to Unite Behind applications. But I want to ask you this. Unite Behind is a complainant. They file a complaint. They are in possession of certain documents. What I want to find out from you, Ms. Ngoye, is prior to October 2017, so therefore prior to Judge Makhubele being appointed as the chairperson, did you ever interact or did you know Unite Behind?
Yes, Chair, I did.
And how did you know them?
Chair, at the time of Chairperson Popo Molefe, when he was the chairperson of the PRASA board, he introduced Unite Behind to us as part of the legal team and the external legal team that had assisted PRASA on the investigations. So that's when, for the first time, I met, in fact, I met Zaki Ahmad in that meeting, and that was in about 2015, 2016, somewhere there, Chair.
So was PRASA at that stage then engaging with Unite Behind?
Well, Chair, one of the things that matters that we were involved in as part of the investigation process was to review those contracts that the board of Popo Molefe believed were irregular. One of these contracts was a contract of Siangena, which dealt with speed gates at the time. And Unite Behind came in as an amicus in that matter to support the, the board's application to court.
Let's just get clarity on that. You met the complainant in this matter somewhere between 2016 and 2017. Is that correct?
2015, 2016, Chair. Yes, that's correct, yeah.
And who raised the issue of these contracts with you?
The contracts that we were dealing with at the time.
Yes,
It was part of the investigation that the board of Popo Molefe
Yes.
was dealing with.
And what exactly did he want to know, or what did the board want to know?
The process was to review
Yes.
those contracts, Chair. And as part of it, and this discussion we had with the chairperson, Popo Molefe, at the time, he was concerned that because of the challenges that he is having, also from Parliament, and I'm speaking first-hand knowledge here, that it was important to engage with civil society in relation to these matters. And therefore, you know, I guess through his contacts, Unite Behind was then involved in this particular transaction, and he introduced it to us as part of the legal team that was preparing the review documentation.
Okay. When you engaged with Unite Behind or any other civil society group, were there documents that would be handed over to them which were part of process documents? For example, if there was a meeting, you'd be able to give them minutes of the meeting.
Well, Chair, I guess that was what happened. They dealt with our external worksmen at the time. You know, whatever documentation they wanted, you know, to get hold of, they got given the documentation to understand what was happening. This was clearly, you know, an agreed process with the board of PRASA at the time.
Having gone through the documents that the bundled documents that have now been before the tribunal, there's an indication that the resolution, the unsigned resolutions of the board for 1 December 2017 came to be in the hands of Unite Behind. Do you know how those resolutions came to be in their hands?
I don't know, Chair. The one thing I can tell you, Chairperson, is that PRASA continues to be a porous environment. So things would leak at any given moment. So I don't know how Unite Behind got hold of that specific resolution.
Okay. Now, before us, we also have a transcript of an interview that was conducted in February 2023. And that chairperson is found in volume 21, and it's from page 49 of that bundle, but I'm making specific reference to page 51. So volume 21, page 51.
I've got a Chair.
There is a reference that if you go to the first line of that document, it says, and most importantly, a whistleblower and corruption ambassador by the name of Martha Ngoyi in the issue of PRASA.
Yes, I can see that, Chair.
Okay. The question is, were you a whistleblower for Unite Behind?
No, I was not a whistleblower for Unite Behind. And Chair, I was, you know, the term whistleblower, I guess, is a term that got given to us, those people that appeared at the Zondo Commission. I regarded myself as a professional who was doing her work and just giving the required information and assisting the Commission with the information that the DCJ at the time had requested. So we've been termed whistleblowers, Chair, and that's what it is.
Okay. If you go on to page there's something that I want to refer you, which is on page 62. This is the time when Mr. Ahmad is being interviewed. Page 62 of that same document. In the middle of the page where it starts with, when the Werkmans reports and the Treasury report started arriving, Popo Malife, who's the only honest chair of PRASA up to now, was also gotten rid of. He got Martha and other people to lay charges under Section 34.
I can see that, Chair.
Did you ever lay any criminal charges against anyone at PRASA?
No, Chair, I didn't. In fact, the Section 34 reports that were done in terms of PRECA were done by the board of PRASA. It was very confidential, Chair. I still don't even know what matters went to the Hawks at the time. But what I knew, I only knew of two specific matters, which was Sefambo and Siangena. But the other matters, I can't tell you what was even reported, but I did not make a specific report in terms of PRECA.
Okay. When Judge Makhubele engaged in regards to the CIA matters, I will say matters because there were 6 of them, the CIA matters, you indicated that the legal department was not part of that engagement.
I did, Chair.
Okay. Was there any problems between the legal department and Judge Makhubele that made her engage with on the CIA contracts without the legal department?
Well, we at least on our side, we didn't have a problem with Judge Makhubele. There was no problem that we knew of. And I think we do say it in one of the letters that we had drafted in response to some of the issues that were raised by the board.
Okay. Did you ever conspire with anyone against Judge Makhubele?
No, I didn't. No reason to do it, Chair. Why would I?
And during this period of October 2017 until March 2018, when Judge Makhubele left PRASA, did you know a person by the name of Advocate Boetus?
No, I've heard of Advocate Boetus. I don't know him. I don't even know what he looks like.
Okay. Chair, those are my only questions I have for the witness. Thank you.
My apologies, my voice is a bit faint this morning. But let me start where, good morning again.
Good morning.
Let me start where you have just left. And I take it that you have volume 21 with you.
Yes, I do. Yes, I do have volume 21.
Yeah, it's the transcript of that media briefing, which Ms. Zungu has referenced. Chair, it begins at page 49 of volume 1. Volume 21, I'm sorry. Are you there?
Yes, I'm there, Chair. Sorry.
Firstly, can we confirm that beyond your introduction to the complainant by Mr. Molefe in 2015/2016, you continued to have an association with the complainant?
Yes, I want to know that.
Can you just assist the tribunal by explaining precisely what has been your association with the complainant?
Well, in relation to, let me speak to this, but you've referred me to this document. specifically?
No. I just want your general association with them. We'll get to the document.
Okay.
Are you a member of the complainant?
No, I'm not, Chair. I'm not a member of the complainant. The complainant is a civil society. It's one of the civil societies that at least one has engaged with in relation to one's, the issues that one has had at PRASA, especially more so after one was fired by PRASA in 2021. So apart from that time, it was in relation to the work that PRASA was doing insofar as the reviews were concerned. But also, after the board of Judge Makhubele, the next board requested that we engage with Unite Behind. In fact, Chairperson Kanyisile Kweyama instructed Fanny Dingusaya and myself to travel to Cape Town and engage with Unite Behind on the understanding of what issues they had with PRASA. When we came back and reported on our meeting with Unite Behind, the board of Kanyisile Kweyama then sent the executive, I can't remember what Sitol, I think he was marketing and so on, to engage as well with Unite Behind with the view of PRASA entering into memorandum of understanding with Unite Behind. So there's been that, engagement with Unite Behind throughout, I guess, for a number of years within PRASA on issues that they were interested in that affected the commuters. So we got to engage with them on that. But I'm not a member of Unite Behind. And there were other instances as well. I guess more so now, Chair, after my as I said, my dismissal by PRASA and the challenges that I have had at PRASA, I've gone out to seek the assistance of civil society, and not only Unite Behind, but of many others, to say help out with this particular issue that one is dealing with. So I've engaged with them.
My question was fairly straightforward, and I'm grateful that from your side, you now confirm that you are not a member of the complainant.
I'm not a member.
Let me move on. A day before this tribunal commenced with its proceedings, the complainant called a press briefing on the 20th of February 2023. I take it that you are aware of that fact.
Well, the press briefing, my understanding, Chair, was not called by the complainant.
Who called the press briefing?
It was a civil society organization called Defend Our Democracy.
Well, the complainant, through Mr. Zaki Ahmed, attended that briefing.
Yes, he did.
And you too attended it?
Yes, I was invited by Defend Our Democracy.
And at that press briefing, which was the day before the proceedings commenced,
Yes, Chair.
you had the liberty of discussing your testimony publicly.
Well, it was not the first time I did it.
Now, please answer my question.
Yes, I did.
Yes. And I'd like to refer you to parts of this. I'll come back to some of them when I ask you specific questions. Can you turn to page 51, volume 21. Chair, I'm on volume 21, and what I suggest, Chair, is that if I move away from a volume I'm dealing with, I will indicate to you immediately. I take it that you're at volume 21, page 51. Ms. Zungu has taken you to that page, especially the introduction, right at the top of it. What I want to establish from you is, do you recall who was the spokesperson who introduced you as a whistleblower?
I don't remember their name, Chair. But they worked for Defend That Democracy. That's
I
what
understand,
understood.
but that person who introduced you regarded you as a whistleblower,
Yes, they did.
and you yourself did not have any quarrel with that description.
No, I didn't.
If you go to page 68 of the same bundle, you will see that under paragraph 10, there is a journalist who is asking a question.
Yes,
Take it that is Ms. Masi Chavas Fularo.
that's right.
Yes. What I'm interested in is the second unnumbered paragraph. Chair, just for context, I'm going to read it and I'll stop where I have an interest in asking a question. Just with you, Martha, we've also been speaking in the media, and the President has brought it up quite a couple of times about whistleblowers, the difficulties they face. So you're speaking about the wrangle to return to your position. What support are you getting as a whistleblower? Do you see that?
I do see, Chair.
She too describes you as a whistleblower.
Yes, Chair.
And then you take the liberty to respond to her question. Do you see that?
Yes, I do.
I've looked at the response and I have come across nothing in your response where you repudiate your description by the journalist as a whistleblower.
Yes, Chair. And I never have.
Then I'd like to take you to page 72 of the same transcript. Another journalist under paragraph 15, Ms. Prabashini Mudli, asks a question. And I'm not too sure whether it's directed to you or to Mr. Ahmad, but I believe Mr. Ahmad is going to testify and we will take it up with him when he comes in. And her question is to the following effect. Chair, I quote, "It's Prabashini Mudli from SABC News. Is there any information on hand that you guys can share possibly about the relationship that the judge had with Siaya prior to joining PRASA? I assume that the reference to the judge in that question, or part of that question, is to Judge Makhubele.
That's correct, Chair.
And that's how you understood the question.
That's correct, Chair.
Then she goes on, because if you say that she didn't benefit financially from any of this, what could have been her reason for aiding and abetting the corruption at the Passenger Rail Association? Do you see that?
I do, Chair.
And then you see the answer by Ms. Zaki Ahmed. Your guess is just as good as ours. To the best of our knowledge, no relationship has been established, and the rest is there for all to see. But let me, from your side, ask you this. Do you have any knowledge that Judge Makhubele benefited financially?
No, I don't.
Do you have any knowledge that Judge Makhubele assisted, aided, or abetted corruption in PRASA?
Well, the facts that I spoke to is what I have knowledge of, Chairperson, in relation to the CIA transaction.
The substance of my question is a little different.
Sorry, I didn't hear that.
The substance of my question is a little different. It talks to the question of corruption in PRASA.
Yes.
Do you have any knowledge that Judge Makhubele was involved in aiding or abetting corruption in PRASA?
My reference to corruption in this particular instance is limited to the CIA transaction. I regarded it as that, even at the time, because I did not, understand, the capacity within which she was doing the things that she was doing. And in the end, I understood to be that, because a lot more had been happening where we had picked up correction, but not in relation to Judge Makhubele, to others. So,
your answer is a little long for me to comprehend. Are you saying that Judge Makhubele was not involved in any corrupt activity in PRASA?
I'm saying the Siyaya transaction, in my interpretation, the settlement thereof is tantamount to a corrupt transaction.
Are you saying that Judge Makhubele aided and abetted that which you regard as corruption regarding the CIA settlement?
Yes, I am, Chair.
Okay. We'll get back to that. This morning, Ms. Zungu asked you about your duties in PRASA. And where we have landed from your answers is that there has not been a written contract regarding your transfer as the group legal risk and compliance of PRASA.
That's correct, Chair.
And you recall that the chairperson asked you whether you generally understood your responsibilities as group legal risk and compliance, and that others in PRASA also understood your responsibilities.
That's correct, Chair.
On the previous occasion, you explained what you regarded as your duties relating to group legal. I'd like to explore with you what you understood to be your duties as group risk executive of PRASA. Because my understanding is that your duties were they were divided into different compartments. One is risk, correct?
Yes, Chair.
The other is compliance, correct?
That's correct.
And the last is legal.
That's correct.
You have testified generally about the third. I'd like to explore this first and second. What were your general duties regarding risk in PRASA?
Chairperson, from a risk perspective, one of the responsibilities I had was to ensure that we put in place the necessary policies relating to dealing with risks. We were identifying the risks that the organization, and this was not only done as a department, but with the entire organization, of the risks that were involved or that we would meet within the organization or encounter, and discuss how those risks would be mitigated. So we had a framework. We had to put in a framework of how risk-related matters needed to be dealt with, and also, putting together that the risk matrix and identifying the necessary the risks according to, the severity. And that was one of the issues that we did as part of, and that would go into the corporate plan of the organization. And as part of the risk portfolio, I was also responsible in overseeing the insurance portfolio Chair, may I explain that in relation to all these portfolios, I had general managers like Mr. Fani Dingiswayo, who were reporting to me as the heads of those respective portfolios. So we identified risks, we advised on how the risks should be mitigated. And I was also not a member, but I was an invitee of the Audit and Risk Committee of the board in light of my position. So just in a nutshell, that's what we did. And I obviously assisted in putting in place with the team the insurance policy, insurance coverage for PRASA, as it fell within my remit.
I assume from your explanation that if there would be a risk that PRASA would face, you will be the first person to deal with that risk.
Well, not necessarily the first person to deal with the risk, but it would probably get to me somehow. I'm not sure I'm understanding your question, Councillor.
Well,
perhaps you can rephrase.
Whatever risk that PRASA would face, it will be your accountability to deal with it.
Well, yes, and advise on it.
You would also have to advise the board of PRASA on it.
Yes, I would.
Can we deal with your duties as a compliance officer, a compliance executive?
Yes, Chair.
Can you please explain to us precisely what that included?
Chair, again, we had to put in place the necessary frameworks within which the organization and policies needed to be aware of and comply with. And we had to also assist in identifying the necessary pieces of legislation, together with the organization, obviously, and on issues that we believed were important and the organization needed to note and comply with. So we would raise those issues. We had documentation that identified those pieces of legislation, and whenever there were changes to the pieces of legislation, we would advise accordingly. And if there was non-compliance of, anything within the organization, we would flag it accordingly. And once again, there would be a report that would go to EXCO as well as the board on compliance-related matters and risk-related matters, as we did with the legal matters.
Again, should there be a risk of non-compliance with primary legislation which regulate the existence of the board of PRASA, its functions and duties, you will be the first person who's accountable to deal with that risk of non-compliance.
Yes, definitely.
And you will advise the board.
Yes.
In that context, can I move on to ask you what you said on the previous occasion when you started your testimony? You indicated that the interim board, which was appointed in October 2017, was not properly constituted.
Yes, I did.
When did you realize, for the first time, that the interim board was not properly constituted?
From the onset, Chair.
That would be around October 2017.
Yes.
When the board was inaugurated by the minister.
Not sure whether the board was inaugurated by the minister.
Well,
but
when the board was introduced to you as an executive.
yes.
Yes.
Well, the minister did not introduce the board to us, Chair. I don't recall that, but I suppose it.
Well, the point of the
Sorry to interrupt, Mr. Malik. I understand that the previous board had come to an end in July of 2017.
Yes, July,
Is that correct?
September, July, August, somewhere there, yes, Chair.
Somewhere it says the previous board before Judge Makhubele's board ended in 2017 in July.
Yes.
Is that correct? So
Between July, August, yes, somewhere there, Chair.
and from that period on until October then, what happened? There was no board.
Well, when the Popo Molefe board, and the timing is probably is going to beat me up here. When the Popo Molefe board, recall, Chair, the Popo Molefe was disbanded by the minister, right? They fought it and came back. So in between the Popo Molefe board and them going to court, there was another board, an interim board that was appointed, that was the board of Mr. Nazir Ali. So when Popo Molefe was successful in his court matter against their termination, they came back as the board. But once again, his board was not correct because he didn't have all the board members. So when their term expired, the board of Judge Makhubele came in after that.
And that board was properly constituted?
Which
The
one?
previous one?
The board of Popo Molefe initially started being a full board, Chair, with all the representatives.
Being a what?
A full board with all the representatives. When there had been issues with whatever it is that the board was dealing with, it started to not comply with what was required from a board perspective, to a point that the board of Popo Molefe could not even sign off financials because it was not correct. So they experienced that issue and they were advised accordingly, not only by us, but by the AG as well. Sorry, to say that the board is not correct and therefore it cannot take certain decisions. So, we were accustomed to knowing what was required from a board perspective. And there was a point where they themselves were not correct.
Thank you, Mr. Malik.
Thank you, Chair. Well, again, just to confirm, you were aware around October 2017 that the interim board was not properly constituted.
Yes, I was, Chair.
And I take it that you rely on the legal succession to the South African Transportation Services Act for your view or contention. That
Yes,
that
I do,
board-
Chair.
I have looked at the documentation which the pro forma prosecutor has made available to us. I have not come across any document wherein you raise the question of the improper constitution of the interim board with the board itself. Can the tribunal safely approach your evidence on the basis that you have not raised that issue with the interim board?
Well, not directly with the board, Chair, but that issue was raised with the acting group CEO at the time to say, please note that this board is not correct, and please highlight it with the current board of the interim board of PRASA.
The question of the...
Sorry, I just want to understand that. The question was, did you raise it with the board itself?
I didn't raise it with the board itself, Chair. I hadn't had an opportunity to raise it with the board itself,
You raised it, you say,
with the group CEO.
with the group CEO?
Yes.
Yes, thank you.
Can you tell me, when did you, on your version, raise that issue with the group CEO?
I raised it right at the onset, Chair. I mean, this was one of the issues that, we found problematic with the appointment of interim boards. So it was right at the onset when the board was appointed. We had this discussion with the group CEO with the hope that, things would be fixed.
On your version, that would have been in 2017, around October.
That's right.
Again, I must suggest to you that I have not come across any document wherein you raised that issue with the group CEO at the time. And I think, if my memory serves me well, the acting group CEO at the time was Lindikaya Zide.
Yes, Chair.
I have not come across any information, any documentation, which indicates that you raised that issue with him or her.
Chair, you won't find the document because this was a discussion that we had orally with him. Him having been present at the time of the Popo Molefe board when we dealt with the specific issue of curation. So when we revisited this issue with the group CEO, it was to say, look, we don't want to be dealing with the same issues that we dealt with the Popo Molefe board. So you're not going to find a written document that speaks to that issue of curation that is directed to the board. However, in our compliance reports, right, that we would prepare for EXCO, the issue of curation of the board was identified.
Ms. Ngoyi, there's a difference between the curation of the board and its improper constitution. I don't want to debate that difference with you. You can accept that the improper constitution of the board has nothing to do with its curation.
Well, that's your interpretation, Chair. Okay. I don't know what Mr. Malaga is alluding to.
I'm not going to waste time debating that issue with the witness. But let me complete my line of question on your version of the improper constitution of this board. We now know that the responsible executive authority for the appointment of board members is the Minister of Transport, correct?
That's correct, yes. Chair.
And I take it that I will not, as hard as I can search, find any document that you addressed to the minister complaining about the improper constitution of the interim board.
No, you're not going to find that, Chair.
And as I recall, at that time, the minister was Minister of Transport at the time was Mr. Masonganye, correct?
That's correct, Chair.
You are aware of that fact?
That he was the minister?
Yes.
Yes, I was aware of that fact.
Yes. What I find strange is this, that it was your duty as a legal risk and compliance officer to notify and advise at least the board about its improper constitution. Correct?
That's correct. I'm not denying that.
And you did not do so.
I didn't do so, Chair. And can I explain myself if I'm allowed? Chair, my evidence in chief speaks to my engagement with Judge Makhubele. And it also speaks, there was a board meeting that was held that I was not invited to. That, naturally in relation to board matters, I understand how it works. you would have various committees sit first before the board sits. It didn't happen. So the opportunity to actually raise that directly with the board of Judge Makhubele with our reports did not arise. And that is why I'm saying to the commission that it was a known fact for me, and I did say the Legal Succession Act does not cater for an interim board, and that was a problem on its own. And we had discussed this with the group CEO because he had more time and was given more time with the board, that when he sits with the board, he would be able to raise this particular issue with the board. So that is my, it's not like I did not do anything about it. I had discussed this with the person who had actually more time with the board than myself, to say, please, can you raise this particular issue there with? And I understand he did. He did raise the issue of the creation of the board with the board.
But as far as you are concerned, you did not raise this issue.
No, I didn't raise it directly with the board, Chair.
Well, no. You say you did not raise it directly with the board. You didn't raise it at all with the board. You raised it with
The group CEO.
the group CEO.
That's right, Chair.
Do you know whether it was taken further by him?
Yes, I do, Chair.
What did he do?
Well, it became, what he had reported to us was that he did raise the issue of the creation and the constitution of the board at one board meeting that was held, and it was an issue that the board was going to consider and discuss with the minister.
Well, can I? I don't want to explore hearsay matters. You talk about what the group CEO or acting group CEO said to you. I don't want to explore that, but I want to explore what your personal understanding is on this issue. This is a very important issue affecting not only the very existence of the interim board, but also the legality of the actions that it may or may have taken, correct?
Yes.
You know, as a legal person, that there are serious consequences for a body that is improperly constituted to take decisions.
Yes, Chair. You did all that.
So this issue of the improper constitution of the board on your version strikes and has struck at the very heart of the existence and legal validity of the board that was chaired by Judge Makhubele.
Yes, it does, Chair.
And you must have appreciated the far-reaching consequences of those decisions that it may have taken.
Yes, I did.
And yet you said nothing to the board.
I didn't say anything to the board. I responded to that question, Chair.
And you said nothing to the minister.
I didn't say anything to the minister, Chair.
Yes.
But also, Judge Makhubele was a legal person. And I know that's not the question you're asking me. The expectation that one had, and that's why I said in my evidence at the beginning that we were very happy to have somebody with legal knowledge coming on board, to head up the function. So one would have expected that at least those issues are issues that the chairperson of the board with the legal mind would have looked at and dealt with. And that's why when I understood from Mr. Zide, and these people can be called to the commission to confirm it, Chair, when I understood Mr. Zide having said to me, yes, we did raise this issue with the board, and the chairperson's response was, we're taking it up with the minister, was, at least comfort for me that it's not an issue that is just going to be left without the board dealing with.
One of the explanations you have just given about why you did not raise that important issue with the board, or at least with Judge Makhubele, is that you did not have an opportunity to raise it with him. Do you remember that?
Yes, I did say that.
We now know, or at least from your evidence, that you have had an opportunity to meet on a one-to-one basis with Judge Makhubele.
Yes, I did, Chair.
And for illustrative purposes, you recall that you talked about the meeting of 14 November 2017, where you met Judge Makhubele together with Mr. Zide.
Yes, Chair.
Yes. So at that meeting, you had the benefit of both Judge Makhubele and Mr. Zide, correct?
Yes, I'm not disputing that.
And yet again, at that meeting, you did not raise this issue with either or both of them.
No, I didn't, Chair.
Yes. Whilst I'm at this issue about your responsibilities, one of the issues that you testified upon, and we'll get to the details in due course, is that the board met at a special meeting of 1 December 2017. And it adopted a resolution relating to the use and the discontinuation of utilizing the panel of lawyers of PRASA. I've read your transcript again, and I can comfortably say to you that part of your evidence in that regard was that you were looking for a signed resolution
Yes,
of that meeting. You remember?
that's correct.
And you also took issue about the validity of that resolution. Remember that?
Yes.
And in the the urgent interim application you made, which was decided by Judge Duchten, in your founding affidavit, you referred to that resolution as the purported resolution. You remember that?
Yes, I do.
Can I ask you this? Do you contest that the board, at that special meeting of 1 December 2017, took the resolution that your department should not use the panel of lawyers that PRASA had at the time?
Chair, I asked for a signed resolution of the board. I wasn't present at that meeting of the board. And there's a reason why we asked for a signed resolution of the board, because things would just happen within the organization where people would say the board has decided this and the board has decided that, and people would act on those specific instructions. Now, having understood the environment within which we were operating, it was important for us to deal with at least a legitimate document that was coming from the then board of Judge Makhubele. So that's what we asked for. I wasn't present at that meeting. I was given a copy of what was said to be the resolution of the board. So I don't know if I can take it any further, Chair. I wasn't there.
Let's take it step by step. You were given a draft resolution, correct?
Yes,
It was unsigned, correct?
that's right.
The minutes of that meeting was minuted. Its proceedings were minuted, correct?
Well, I saw the minute for the
Yes.
first time when I was shown by the evidence leader.
Indeed. And she took you through various parts of the minutes of that meeting.
Yes, Chair.
On the face of it, they appear to be the minutes of the special board meeting held on the 1st of December 2017.
Yes, Chair.
And I take it that you have no issue about the authenticity of the minutes concerned.
I don't, Chair. I think if I recall, I can't remember if the minutes were signed. I don't have an issue with that, the
Yes.
authenticity of that minute, Chair. I don't have.
They speak to the very same issue which the resolution that was unsigned, that was given to you, spoke to. Correct?
That's correct.
Yes.
Chair, can I say something on that?
Chair, I don't want Ms. Ngoyo to suggest that she has been not afforded an opportunity to respond to my question. If she has to and she wants to, by all means, we'll delay my question to her.
Ch-
What is it that you want to say about the resolution?
Chair, when we were,
Sorry, I think the mic was off. Just what is it that you wanted to say?
Chair, when we were given, I think it's important to understand the sequence of events. When we were given that excerpt, it was not a full minute of the board. It was just an excerpt, what was said to be an excerpt of the board minute, right, that dealt with the issues that were at. That's the only document we got to see. We did not see the minute that the full minute of that particular board meeting. So we were working with a document that was taken out of, our understanding was that it was taken out of a discussion that was there at the board. And that's why we insisted on a signed excerpt to be given to us. So the issue of the minute arises only here, where I see that minute. It arises here when I was asked by the evidence leader.
Are you saying you never saw the minute of the meeting of the 1st of December at all?
I have never seen it, Chair. I've never seen it. I think I saw it for the first time here.
And what you saw was not the minute, but an extract of the minute.
Yes, what we were given was an
Yes.
excerpt, of the minute, of what was discussed at the board.
Yes, but at the time, you were waiting for a signed resolution.
We were waiting for even a signed excerpt,
Yes.
Chair, would have at least given us comfort that the issue was indeed, properly ventilated at the board.
Was it ever confirmed in any manner whatsoever that the board had dealt with the issue of other attorneys for PRASA?
Not in writing to us, Chair. We waited, and that's why when we wrote to the chairperson directing that specific memo to the chairperson, we said, I think if I recall, that we write, even though we had requested that this information be provided to us, and at the time that we wrote, it was still not provided to us. And we said to the chairperson, if this is what had been decided at the board, these were the concerns that we had. Can we, as the legal department, be given an opportunity to engage with the board and explain the concerns that we had? So that's the memo that we felt. After we realized that we're not getting the signed excerpt from the board, we then felt it necessary to address a memo to the chairperson of the board, bringing this particular issue to her attention specifically. And that's what we did.
Do you know what the follow-up to your letter or your correspondence was?
Chair, if I recall, we didn't get a response to our
Call it a query.
our memo.
Yes.
We didn't get a response. But we spoke as executives, Chair, and once again, Mr. Zide is still available.
No, you say you spoke. To whom did you
To,
speak?
to the Group CEO, Mr. Zide,
And,
at the time.
yes,
And Mr. Zide did indicate to us that the chairperson was upset that that particular document was given to the legal department. That's what he told me,
yes,
and left it at that.
thank you.
Chair, again, I'm not going to pursue hearsay statements on fundamental matters that affect her responsibility, but trying to shift away from her responsibility through that hearsay evidence. I'm not going to pursue that. But the issue of the impropriety of the panel of lawyers which PRASA had when Judge Makhubele came to office was not a new matter, as far as you know, because it was already flagged and raised by the Auditor General when she audited PRASA's financial affairs and financial statements for the year ended 2017. You are aware of the fact that the Auditor General had raised her concern about that issue.
Yes, I was, Chair.
And in fact, her audit finding was that that panel was improperly constituted, and raised questions of irregular expenditure with reference to the procurement of legal services using the panel, correct?
That's correct, Chair.
So that the board of Judge Makhubele, when it came into office, it was well within its right, if not its duties, to deal with that question.
I'm not disputing that, Chair.
And therefore, there would be nothing sinister in the board which met at a special meeting on the 1st of December to take a resolution that the legal department should discontinue utilizing the panel of lawyers.
Well, there was nothing sinister, Chair. The expectation that we had at the time was at least the board would have engaged to understand what was to happen. And they were to at least tell us what was to happen with those matters that were current, and you know how the organization was intended to deal with them. That's all we wanted. We were not questioning the ability of the board to terminate the panel, but we were not guided as to what must happen, because on reading that excerpt, it said, stop using the panel, and the question was, then what? What happens to the current matters? What happens when a summons is received tomorrow? What do we do? And that particular clarity was a clarity that we were seeking. And that is why, you know, in our response, we had sought to interact with the board, at least to be guided on that and to understand their thinking and to carry on, you know, as best as we possibly could in the circumstances. But we never had that opportunity. In fact, our memo was not responded to.
Well, I mean, we have looked at that resolution. We can go back to it if we have to. It told you precisely what the legal department should do, and that is to use the panel that the South African Civil Aviation Authority was utilizing.
It did, Chair, but once again, that decision was contrary to, it was irregular in itself, because it relied on Regulation 16, and these are the things that we identified. to say we can't just, be expected to use Regulation 16 and it's dumped on us to say use this panel because there's another state-owned entity that has a board, and therefore just go ahead and use that. We had advised previously on this issue, previous board on it, and we believed that the board of Judge Makhubele would have used the same regulation to appoint the SAE aviation panel, and it couldn't. And if it was properly advised, that particular issue ought to have been raised at that board meeting that decided that, but it wasn't, clearly.
So on your approach, because on your version the board did not give you guidance, you went ahead to utilize the panel of lawyers in respect of whom the Auditor General had already made a finding of unauthorized expenditure.
We did, Chair. I mean, the reality is some of these matters started years before this particular finding was made. They were running for years. I mean, what do? Do you just stop and then you allow a new panel to be put in place? I think what is important to state, Chairperson, it's that it's not like the legal department was not trying to put a panel together. In 4 occasions that the legal department went out to remedy this specific issue that was raised by the AG, the procurement department scuppered the process. And we would be told at the last minute that no, this particular tender we will no longer proceed with. So we found ourselves, we were the end user, found ourselves stuck with what we had. And that is why when that purported excerpt came to us, we wanted to make sure that indeed this was coming from the board. And we would request, even though that was the case, Chair, to be given an audience by the board to explain to the board the challenges we would have with a particular resolution that they would have made in relation to the panel.
This is one of the issues which strikes at the very heart of your duties as a risk and compliance executive within PRASA, to make sure that PRASA does not suffer the unauthorized expenditure findings by the Auditor General, yet again.
Chairperson, it's very unfair what obligations are placed on me as the sole person within the organization to be responsible for these things. And I'm not saying, in certain respects, yes, one would have to identify these things when you know about them. In this particular instance, Chair, and I've just explained it, we went out 4 times. It started even before I was the Group Executive of Legal to try and put the panel together. It never happened, Chair. I think to date, the issue of the panel of PRASA is still a problem. But it is, I find the question very unfair to say I was responsible for making sure that irregular expenditure did not occur within PRASA. Some of these decisions were taken where I was not even party to those decisions. So, I think that's a very blanket statement to impose that obligation on me alone.
I'll explore the fairness of that question with you. Let me start here. You know, or if not, you should know, as a risk, legal, and compliance executive of PRASA, that when you, for whatever reason, are going to incur unauthorized expenditure, and you can't avoid it, you will have to apply to National Treasury to condone it or to exempt you from any possible finding of unauthorized expenditure. You know that fact, don't
I'm
you?
aware of that regulation from Treasury, Chair.
Very just want to understand why in which you said you find yourself in helplessness. So in helplessness, Advocate Malika, we are sitting here as a tribunal and we're supposed to be inquisitorial. It's not my intention at all to interfere with your cross-examination, but it's not a normal trial here. We got to come in when we have to. Mr. Ngoya, it's only after last night when I read the extra bundles, and it was specifically stated in one of them that you are in fact a qualified lawyer. You are admitted as an attorney by the High Court or Supreme Court, then is it right?
I did say that right at the onset, Chair, when I gave evidence. Yes, I am an admitted attorney.
You are an admitted attorney?
Yes, I am.
Yeah. And by the people under you, in your legal department, the evidence shows that they were all legal people as well.
They were all admitted attorneys, Chair.
All of them, yeah.
Yes.
So you could deal with legal matters internally
Yes, we could.
if you wanted to.
I'm not sure I understand the question.
Sorry.
I don't understand the question if we wanted to. What that alludes to, Chair. Can I get clarity on that?
Well, as a legally qualified admitted attorney, you receive documents, for instance, about Yaya. You could enter an appearance to defend.
No, we couldn't,
You
Chair.
could not.
We're not practicing attorneys.
Sorry?
We're not practicing attorneys.
Oh, I see.
Even though we are attorneys, we're not practicing attorneys.
Yes.
And we understood that when we get a summons, we have to instruct a firm of attorneys to
But
assist.
none of you,
And no, we couldn't do it.
none of you had the right of appearance
No,
too
we
in
didn't,
the- in
Chair.
the High Court. Yes, thank you.
I just want to take that further. So the legal department at PRASA couldn't act as PRASA's attorneys, is that correct? They would outsource whatever court procedures were brought against PRASA. Would
Yes,
that be correct?
It was litigation, yes. Every other thing we did internally, yes. It was
And
litigation.
that was the position.
That's correct, Chair.
Now, the panel of attorneys that PRASA had, what precisely was the complaint about those attorneys?
Chair, the panel of attorney that PRASA used and had used for a very long time had been a panel that PRASA inherited
Yes.
from Transnet. So when the businesses were sold, from Transnet to PRASA, that particular panel, that's the understanding that I had, because these things happened before my time, that the panel was also, just continued with from that perspective. And yes, there was a need to put in place a panel for PRASA's specific attorneys itself.
Now, the complaint that came from, let's call it, the 2017 board, what exactly was that complaint concerning those attorneys?
It was that the AG, my understanding is that the AG had found that the panel was irregular, and it, according to that particular, the board, was that it could not be used at all. And because it continued, the organization continued to incur irregular expenditure. So, and that's something that we've been dealing with, even with the previous board's chair. So the challenge that we had was that some of these matters were very long matters and had happened before. And that explanation was given to the AG whenever we were asked these questions, and we had to show proof of that. but we found ourselves having to continue with that same panel with the hope that we would put a new panel in place and then take on, new instructions using the new panel. Because one of the issues that we considered, Chair, was the costs that would be involved in having to restart these matters or stop these matters because of the panel that was irregular. Everybody acknowledged that the panel was irregular, and that's why there was a drive to put in place a proper panel.
Thank you.
Chair, if I may follow up for your clarity, and otherwise we can take tea adjournment now, but I'd like to just clarify the very important question that you raised. Ms. Ngoye, you know that if you incur an irregular expenditure, contrary to the provisions of the PFMA, you will be committing a financial misconduct under the PFMA.
I'm aware of that, Chair, and when we talk to irregularity, and that's why you have a process from National Treasury that then tells you what it is that you then need to do to deal and report that irregularity, right? The understanding is there. You commit something irregular, contrary to Section 54, it is a problem, it's a financial misconduct, and there needs to be consequences. Now, in relation to this particular issue, and what became important, Chair, was to understand the fact that not every irregularity amounted to unlawfulness where you would say there was fraud and issues like that. And so we looked at it on that basis and said, this is how we would then go forward, reporting these irregular expenditures to the AG whilst we are trying to remedy the situation we found ourselves in.
And you know that whereas here the AG has already made a finding of irregular expenditure, and you continue to repeat it, the AG would be entitled under, as I recall, Section 20 of the Public Audit Act to impose a remedial measure against you as the relevant accounting authority or accounting official.
Accounting authority, yes, Chair. Accounting official, yes, Chair. I'm aware of the provisions of the PFMA.
So it is not only the fact of incurring unauthorized expenditure, it is the obligation to deal with it in order to avoid it.
Yes, Chair, I don't dispute that.
And I've suggested to you, in fairness, that in this case, there was a gateway to deal with this unauthorized expenditure, to approach National Treasury for either condonation or exemption. Is that a fair way to ensure that a public entity such as yours would deal with that irregular expenditure?
Chair, it's not like these issues were not explored. The National Treasury is very clear when it comes to issues that must be taken to tender. You don't just apply for an exemption because you can't get your house in order. You don't do that. They're not going to grant it. These issues were explored with the National Treasury, and they were refused, and they continue to be refused to this date, Chair, because where you're supposed to have a proper procurement in place of a particular process, you must go ahead and do it. And that's where we found ourselves stuck, and that's why I repeat that 4 times the legal department went out to try and remedy the situation. And we were scuppered and had no control of putting a proper panel in place. And we had to deal with the situation the way it was. And it was reported accordingly, Chair. We didn't hide the fact that we were having these challenges within the organization. even when the AG came again, we had evidence of showing this is what we're trying to do, and, but this is where we landed up.
Well, the record will speak for itself, but can I just, before we take an adjournment, Chair, confirm that you have just stated that not every irregularity equals corruption?
That's right.
Okay. Thank you, Chair.
Yes,
I mean, I didn't say corruption, Chair. I didn't mention the word corruption. I spoke to unlawfulness.
yes. Yes, thank you. We will take the adjournment. 15 minutes, please.
Thank you, Chair.
Thank you, Chair.
Yes, we are ready to commence again. Advocate Maleka?
Thank you, Judge. Chair, I'm now going into the matters of detail, and I would like to start off with Volume 8. And Chair, the starting point is the application for interim interdict, which PRASA brought and served before Judge Turton. Ms. Ngoye, on the previous occasion, you explained the background to this application, and I'd like to confirm some few factual matters. This application was brought around the 3rd of April 2018, as far as I recall. Correct?
Yes, Chair, I think.
Let's Let's look at page 6 of volume 8.
Page 6 of volume?
The very
Sorry,
volume before you, volume 8. You will see that the date of the notice of motion is the 3rd of April 2018.
Yes, I do see that, Chair.
By that time, Judge Makhubele was no longer at PRASA, to your knowledge.
Yes, I know that, Chair.
And my understanding is you did not serve this application on Judge Makhubele.
No, we didn't, Chair.
And in it, you make serious allegations about her.
Yes, Chair.
And that application was heard in her absence, and a number of observations or findings were made by Judge Turton about her. I take it that you have read the judgment of Judge Turton.
I've read it, Chair. Read it a while ago, yeah.
Yes, the simple point is that she relied on your version to make adverse findings about and concerning Judge Makhubele.
Yes.
Why did you not authorize Bowman, who was your attorney, to serve this application on a person you accuse of serious allegations, including allegations of aiding and abetting corruption in PRASA?
Chairperson, this matter was the second part. What Judge Turton was dealing with was the second part of the application that we had brought before court. So, the advice was, these are the parties that we are dealing with, and we would like to interdict the settlement agreement that was entered into between those parties. So we followed from that, and one acts obviously on the advice of your counsel, and they knew exactly what we were saying as far as the affidavit is concerned. So
Why did you not serve Part B on her?
I didn't serve Part B on her. I can't explain why it was not served on her, but it wasn't served on her.
No, but I mean, your explanation is that the reason on advice you did not serve Part A is because you're dealing with matters relating to Part A. Part A was granted, we know that, by Judge Tuchten.
Yes.
What about Part B? Why did you not?
It was not a different matter, Chairperson. It was the same parties, at least that's my understanding. It was the same parties that this particular matter was dealing with, and Judge Makhubele was not part of Part A. And when Part B came, it was in relation to the same parties. So we were not advised to include Judge Makhubele in that. We related the factual issues in support of the rescission of the judgment that was taken, where we as PRASA were not recognized based on the instruction that she had given.
You are a lawyer, and I don't want to repeat the old record. You know that one of the fundamental duties of fairness requires that if in litigation you make serious allegations about someone, it is fair to draw the attention of that person to those allegations, especially whereas here, the allegations relate to someone who was your chairperson, who had retired from office by the time you make those allegations.
I can't dispute that, Chairperson. But that's how it happened. I'm not going to justify why we didn't do it. It wasn't done. And that's what we were dealing with.
Can I ask you to go to page 17 of volume 8?
I'm there, Chair.
And I'd like to draw your attention to paragraph 37. And just so that we are at 37, Chair. My apologies. In paragraph 37, you say the following: the matters were going to be heard and argued before Judge Brandt until there was intervention which led PRASA's erstwhile attorneys, Diale Mokhwasha Inc., being instructed by the former chairperson of the interim board of PRASA, now Honorable Judge Makhubele. Let me stop there. The thesis of your complaint with reference to the settlement agreement is that it was a secret settlement agreement, correct?
That's correct, Chair.
You repeated the same thesis when you made several affidavits and testified before Judge Zondo in the Zondo Commission of Inquiry, correct?
That's correct, Chair.
And you know that Mr. Mokhwasha was called upon to testify about what you said and what Mr. Dingiswayo said in support of your version of a secret settlement. Remember that?
At the commission?
Yes.
Yes, yeah, even though I didn't listen to his evidence, Chair, but I remember he was called.
And we can go to his affidavit if it's necessary, because it's one of those documents we received after your first session of testimony. In that affidavit, Mr. Mokhwasha repudiates the suggestion that the settlement he was involved in was a secret settlement. Do you know that?
I don't know that, Chair. That's his view. My view is that it was a secret settlement.
Well, maybe we should go there, Chair. Chair, I believe is volume 11, capital A. Ms. Goya, can I ask you to go to page 5 of volume 11, capital A? And
Sorry, Chair, I'm not sure how these pages are numbered. I start at page 238 here. I don't know. This is volume 11.
indeed, Chair, indeed. Chair, as Ms.
22 here.
Goya is looking at the papers, I can, without any fear of contradiction, indicate the context to this affidavit. Yes.
Is this one? It's volume 11 that I have before me, Chair. No, it's not volume 11A. I've just been given volume 11.
It's 11, capital A. Indeed, indeed. Yes.
I've got it, Chair.
Thank you, Chair. Ms. Goya, the background to this affidavit is that you and Mr. Dingizwayo had filed affidavit with the State Capture Commission, in which you made several allegations about the settlement. And the Commission's evidence leader, in that case, Mr. Soni, considered it advisable that Mr. Mukhashwa should be given an opportunity to respond to your allegations relating to the settlement agreement. And he filed the affidavit, which has now been placed before you, as Exhibit SS13, as you can see from page 1 of volume 11A. But the point of my concern that I'd like to raise with you starts from page 5 of volume 11A. Are you there?
I'm there, Chair.
And Mr. Mukhashwa gives the context to his affidavit in paragraph 6. It's of no concern to me. But I'd like to draw attention to paragraph 7, I've had an opportunity to consider the affidavits of Ms. Ngoye and Mr. Dingizwayo, as well as other documents that relate to matters of Siyaya Group. I confirm that the averments contained in these affidavits are a correct recollection of the events that took place, except where I otherwise in this affidavit proffer a better clarity and/or put issues into their proper perspective in areas where our firm's involvement was concerned. That's the context. Now, where he puts a better clarity to the issues you testify about is from paragraph 8. In respect of paragraph 38 of Mr. Dingizwayo's affidavit, I wish to categorically state that I and our firm have never been part of any secret settlement. Do you see that?
I do see, Chair.
Yes. All our dealings in this matter have been transparent, and we acted on written instructions from process official. Do you see that?
I do see that, Chair.
I'd like to draw your attention to page 21, which is the date on which Mr. Mukhashwa signed this affidavit. 19 May 2020. Do you see that?
Yes, Chair, I do see it.
First thing first, are you aware that Mr. Mukhashwa disputed any suggestion that he was involved in a secret settlement?
I'm not aware, Chair. I'm seeing it. I've not applied my mind to his affidavits that he wrote to the Commission, but that's his own interpretation of what transpired at the time, because he was involved, so he wouldn't regard it as a secret settlement.
Yeah, but why do you suggest that this was a secret settlement?
Chairperson, I mean, I've stated it. The rules were clear. The policy is clear. The legal department was excluded from this process. It was against policy that what was happening within the organization. And I think, Chair, if I recall, in the settlement itself, I just don't have a copy of it, and perhaps maybe if I can be assisted and be preferred with a copy of the settlement agreement, what was given to the finance team to pay. There was reference to the fact that this was highly confidential and not to be communicated. Can perhaps maybe one be reminded of that, if I do recall?
Are you saying that there is a document which states that the settlement was to be confidential,
Yes, Chair.
and that document you saw?
I did see that document, if I recall. It did say that, and that was one of the things that was alarming, to say, why is this thing not supposed to be seen by other people?
And when did you see it, and where did you see it?
I saw it for the first time when the group CFO at the time, Ms. Yvonne Page, showed me a copy of this document that was a document that said that PRASA did not accept any liability, and I think in there it spoke to how this document needed to be kept confidential.
And was it an affidavit, or what was it?
It was a document that she had received
Yes,
that was coming from the group CEO on the instruction, as I understood it,
yes.
of the chairperson. So it was a document that was intended to be used for payment purposes. It was this, yeah.
And she had the document?
Yes, she got given that document, yes.
Yes, thank you.
So your suggestion that this was a secret settlement was based on the fact that it contained a clause relating to confidentiality?
Well, not only that, Chairperson, the manner in which this thing was done.
We'll get to the manner. That's
Yeah.
the second reason, the manner in which it was done.
Yes, it was all encompassing, Chair. My view was that it's all encompassing. That it had that, Chair, these things happened many years ago. And that's why I'm asking. If the document is available, can we look at the document and see what it said?
We will ask Ms. Zungu to place it before you, maybe during the lunch adjournment, so that you can have a look at it. But for now, and it's important for us to ask you these questions because you put conclusions on certain documentation or events, and with the greatest respect to you and your conclusions, we would like to interrogate that conclusion.
I don't have a problem, sorry, Chair, with that, but I would like to see the document that, I'm making reference to in light of what I have said, also in the affidavit that I would have done.
All right, we have explored two considerations. The one is the confidentiality clause. The other you suggest is that the manner in which this settlement was done suggested that it was secret.
I've said that, Chair.
Yes.
Policies were not complied with, and
Can I
the
ask
reason
you,
why we were excluded.
which policies are you referring to?
I'm talking to policies of how, matters are needed to be dealt with internally. Legal matters, how, we're supposed to be approaching lawyers, how we're supposed to be dealing with issues, how it is that settlements are supposed to be entered into. I gave my evidence in chief right the last time, Chairperson, where I asked the group executives responsible for these particular divisions whether they knew about these settlements. And they said to me at Exco, they didn't know about them. If this was really not secret, those people would have been consulted, at least if it was not important to consult the legal department.
All right, let's add the third consideration. The fact that your group legal executive team were not consulted on this settlement makes it secret. That's your view of things, correct?
Chair, I've responded to that. I'm not sure what Mr. Maleka wants me to say further. And I'll go back to the document, Chair, that I saw, and my reference to secrecy. So,
Ms.
I just
Ngoya?
want to, sorry, Mr. Maleka, I just want to get clear. You say the document that you saw made the point that this was supposed to be secret,
yes,
that it deliberately excluded the legal department.
there was no reference in the document to the exclusion of the legal department, right? But there was a reference to the document being a secret document.
You say that appears in the document.
Yes, if I recall, Chair. And that was one thing that was alarming for me, to say, why is this thing a secret? And as I say, Chair, with the greatest respect, these things happened many years ago. And
Yes.
I'd like to be given the opportunity to speak to, what I see in front of me.
Yeah. We will see if we can give you that opportunity.
Thank you, Chair.
Ms. Ngoya, either you're going to help the tribunal or you're not going to. And I'll appeal to you to try and be patient with us as we ask you these questions. Because the tribunal is relying on your accusation against Judge Makhubele in order to inquire into the matters and in due course make a finding. Now, you have advanced three considerations about why you say this was a secret settlement, and I'd like to explore them in due course. If you can think of more, please do and tell us in due course. I understand that we'll be here tomorrow.
I understand that, Chair. I thought what I was doing is assisting, Chair. I'm not sure where I'm going wrong with my approach to responding to the questions.
Can I take you back to paragraph 37 on page 17 of your affidavit? It's still volume 8, Chair.
It's paragraph 37 of my affidavit. in volume 8.
The one that we have just read in part.
I have it, Chair. Sorry, can I just get some?
And I have read the first 4 sentences of paragraph 37, and I'm going to continue with the rest, if you don't mind. In order to show respect to the court, Judge Makhubele, and to distinguish the fact that Judge Makhubele was, in relation to the facts set out below, acting not in her capacity as a judge of the Honorable Court, I refer to her as Makhubele, as I do with other actors in this matter. Do you confirm that that is your attitude and how you regarded the action of Judge Makhubele as you describe them in this affidavit? She was not acting as a judge when she was at Prasa, correct?
Well, that's what I'm saying here, Chair. That's my understanding of the issues that I was dealing with at the time, yes. And I've said it here in my affidavit under oath.
And I'd like to put some few propositions to you, because those would be the basis of our argument in due course. When Judge Makhubele came to office as the chair of the interim board in October 2017, she was not acting as a judge, correct?
Well, I don't know if that's for me to, she was not acting as, she was the chairperson of the board, Chair.
To your knowledge,
Yes, she was the chairperson of the board. I took her as the chairperson of the board.
she did not introduce herself to you as a judge, correct?
No, she didn't say I'm Judge Makhubele, but that particular issue to say she was appointed as a judge, I remember came. But as to when, at the time, she was the chairperson of the Prasa board.
Yes. When she met with you, at least on the 14th of November, she was not meeting with you as a judge of the High Court.
No, she wasn't. She was the chairperson. I went to see the chairperson of the Prasa board.
When she addressed memos to Mr. Zide and asked you to deal with her concerns in that regard, including the Siyaya matter, she was doing so not in any capacity of a judge, correct?
That's correct. That's my understanding, Chair.
In fact, for your benefit, if you don't know, Judge Mlambo came to testify before this tribunal and indicated that she notified Judge Makhubele that the president had made an appointment of her as a judge with effect from January 2018. Again, I suppose that you would have no reason to dispute what Judge President Mlambo said to the tribunal on that score.
No, I wouldn't, Chair.
Can I take you to paragraph 41 on page 18 of your affidavit?
I'm there, Chair.
And you say something interesting in that paragraph. You say that shortly after her appointment as a judge, and on 19 October 2017, the former Minister of Transport, the Honorable Joe Maswangwanye MP, appointed Makhubele and three other persons as an interim board of Prasa. Do you see that?
I do see it, Chair.
I suppose that that part of your statement cannot be correct. Where
Well-
you suggest...
Sorry?
Go ahead.
No, go ahead. And sorry, I'm sorry I interrupted.
The opening statement of that paragraph 41 says, shortly after her appointment as a judge, and on 19 October 2017,
Yes, I see that, Chair.
that part of your affidavit is wrong.
Okay, if you say that, Chair. That is what I understood at the time that I deposed to this particular affidavit and what was out there. When and as I explained, when the chairperson was talking to us, it was the chairperson of the PRASA board. But we got to understand these facts clearly from a timing perspective as we were going along. If it's wrong in terms of my interpretation of that, then I can't argue the matter further.
No, but we now know, and I'm not suggesting that you should have known any better. The simple point is that on the evidence before the tribunal at this stage, Judge Makhubele was not appointed as a judge.
Okay, I accept that, if that's what you're saying to me. Yes. We had received this information, Chair, as we were going along, and this particular issue was an issue that clearly was a concern. And so that was my understanding, and I put it in that way. And this is what you're telling me.
This is not what I'm telling you. I'm suggesting to you that you make allegations that are not correct on the facts because you have not investigated the correctness of those facts when you made them.
That was my understanding, Chair, of what the position was, and as I put it that way.
I'd like to explore that.
Yeah.
Where did you get that understanding from?
Chair, I've explained. One thing I've responded to is that in one of my meetings, for me, what I observed about Judge Makhubele was it was very important to indicate her status as to what she was. She didn't have a problem with it. And that is why, for me, reference to a judge was something that I had heard from her. But as to when, I suppose, you know, the technicalities of her being a judge are concerned, you know, I guess I didn't investigate those. I didn't deal with those at the time, so. That's how I understood it, and that's how I put it there. So I understood that by the 19th of October, and that's my understanding, she had already been appointed as a judge, which I understand now is an issue that is in dispute.
You know that one of the charges leveled against Judge Makhubele is that she was acting in PRASA and fulfilling her duties in PRASA as a chairperson when she was a judge. I take it that you are aware of that part of the charge. In colloquial terms, we refer to it as moonlighting. Are you aware of that?
I'm aware the accusations are there, Chair, in terms of,
Yes.
of that.
And your statement in paragraph 41 looked at its own terms is suggestive of the correctness of the charge. Do you accept that?
Well, it doesn't have to be accepted as the correctness
No, no.
thereof. Chair, I think it's the issue of Judge Makhubele being acting as a judge at the time is an issue that is dealt with separately here. I am dealing with what I understood had happened at the time, and in terms of her appointment. So I understood that by the 19th of October, 2017, she had received some notification to the fact that she was going to be the judge. She was going to be a judge. So, and this is something that she had alluded to herself. So if that is wrong, and I took it further, and I seem to have perhaps misrepresented it, it's not something I'm going to argue about, Chair. It's an issue, I think, that will be dealt with by other people, insofar as that is concerned. But I understood that at that time, the appointment of a judge was already conferred on her.
see your affidavit was deposed to on the 3rd of April 2018.
Yes, Chair.
And is that what you understood then? Or did you understand it to be on the 19th of October 2017?
I understood it from the 19th of October,
Yes.
2017.
And your understanding was based on an assumption, correct?
Well, on what I'd heard on what was before me, Chairperson. I'm not sure what assumption I made, because it was out there that there was an appointment of Judge Makhubele as a judge. So,
You did not go to Judge Makhubele and say, please give me your letter of appointment as a judge.
no, I didn't,
Yes.
Chair, I didn't.
And you did not see any media announcement or public notice by the JSC indicating that Judge Makhubele had been appointed as a judge by the 19th of October 2017.
I don't remember, Chair. I can't recall having seen anything out there or anything, but I was relying on, obviously, the part of the information that she had given to me.
I suggest to you, and that's what, in fairness, we'll argue before the tribunal, that the first sentence of paragraph 41, where you suggest that by the 19th of October 2017, Judge Makhubele had already been appointed as a judge, is false from beginning to the end of it. You're welcome to comment if you
I
want.
don't have a comment on that, Chair. It's not for me to do that.
Sorry, before I leave this affidavit. Can I ask you to go to paragraph 42 on the same page of volume 8?
I've got it, Chair.
And in it, you say the following. On 9 November 2017, Makhubele requested a meeting with me for the purposes of having a better understanding of the work of group legal services, in particular, the forensic investigation that was conducted by Worksman's attorneys. I invited the second most senior colleague of the group legal services, Mr. Dingizwayo, to this meeting. Mr. Zide, who is process company secretary and was then the acting group CEO, was also present at this meeting. This meeting was also in preparation of a meeting between the interim board and the portfolio committee of transport. I take it that you confirm now, as you did when you took an oath, when you executed this affidavit, that that version is correct to your knowledge.
The version of the meeting happening, I gave evidence to that effect, Chair, to say the first meeting. Wanted to get that clarity in light of the preparation to the PCOT. I've given this evidence, Chair.
Well, I'm trying to interrogate your evidence.
Okay.
The fact that you gave it before doesn't make it acceptable until the tribunal makes a finding in due course. At the moment, we are entitled to interrogate your version. Do you accept that?
I accept, Chair. I mean, I guess as far as what is required of me here, I've got nothing to hide, and I'll say what my understanding is and what transpired, dealing with factual issues that I understood at the time.
I take it that there was nothing unusual when Judge Makhubele invited you to attend the meeting of 9 November 2017.
No, there wasn't, and I did say that before.
In fact, as a chair of the interim board, she was entitled to call that meeting with you.
I've not disputed that,
Yes.
Chairperson.
And one of the most important issues at that time to be discussed with you, Mr. Dingizwayo and Mr. Zide, related to the so-called Worksman's Report, correct?
That's correct, Chair.
And we now know that Worksmen's are the attorneys who had provided forensic and investigating services to PRASA, and they had prepared a report, and that report was highly topical at that point in time, correct?
That's correct, Chair.
And Parliament, through its relevant portfolio committee on transport, wanted PRASA to come and account to it about that report, correct?
That's correct, Chair.
Yes. You made a suggestion earlier upon the questions which were put to you by Judge Mushidi when you testified earlier, that Judge Makhubele focused on the CIA litigation.
Yes, I
Remember that?
did. Yes, I did, Chair. I did.
This paragraph that I have read out to you indicates that Judge Makhubele was also concerned about the Worksman's Report, which was prepared by a firm of attorneys, correct?
That's correct, Chair.
Yes.
I was specific to litigation in this regard, Chair.
But this report also dealt with matters that led to litigation.
Yes, but they were not talking to settlement of a litigation. And that is why my specific reference to CIA was around the possible settlement of the CIA matter.
I'd like to take you to paragraph 43 of your affidavit on the same page. And in paragraph 43, you say, on 14 November 2017, Makhubele requested a meeting with me to ascertain the status of the matters between PRASA and CIA entities. I attended the meeting with Zide. Zide and I indicated to her that these matters were defendant, and we believed that PRASA had a good prospect of success. Do you see that?
Yes, I do, Chair.
So this is the second meeting you had with Judge Makhubele in November 2017.
Yes, and I've given that evidence.
And I suppose that you'll accept that there was nothing secret about that meeting.
No, there wasn't anything
Yes.
secret about.
Now, I'd like to take you to a memo which Judge Makhubele addressed to Mr. Zide after that meeting of the 14th of November 2017. Again, Chair, it is in the same volume. Let me look at my notes. I think that will be easier. It's the 17th or the 19th. I suppose it is volume 8, page 248. No. Are you there at volume?
I'm sorry, Chair, I am there, yes.
Yes. Let's look at this memo. You will see that it is addressed by Judge Makhubele on the 28th of November 2017. Do you see that?
I do, Chair.
And she describes herself in that memo as Chairperson Interim Board, as Advocate T.A.N. Makhubele SC. Do you see that?
I do see that, Chair.
And I take it that you have seen this memo after Mr. Zide had sent to you.
Yes, I did see.
And I think she sent to you, if I'm not mistaken, on the same day or on the 29th.
It's on the 29th.
Indeed. And you must have picked up, when you read this memo, that she describes herself as Advocate Makhubele.
I must have done what?
Realized that in the memo she describes herself as Advocate Makhubele, SC.
Look, Chair, it didn't concern me. It came from the chairperson of the board. I mean, I wasn't concerning myself about the designation and the acronym. I don't know what that's supposed to. It came from the chairperson of the board. We needed to deal with it. I didn't focus on the descriptor.
The descriptor is important. There is nothing in that memo which suggested to you that she described or purported to hold herself out as a judge.
There isn't, Chair. It's very clear.
Yes. And you'll see the subject matter of that memo is inquiry in terms of section 417, 1 and 418 of the Companies Act. Do you see that?
I do see, Chair.
And ordinarily, that is the type of an insolvency inquiry authorized by the Master of the High Court in respect of a company which is the subject of a liquidation order. Take it that you know that.
I do know, Chair.
And the person who presides at that inquiry will be an independent person appointed by the Master.
I understand that, Chair.
Yes. The significance of it will become later. And you'll see the memo is addressed to Mr. Zide. Do you see that?
Yes, I do.
And she says in paragraph 1, I refer to various discussions between us about this matter, as well as a brief discussion with the Group Executive Legal Risk and Compliance, Ms. Mathangoy, on 14 November 2017. Do you see that?
I do see, Chair.
Yes. And in fairness, Judge Makhubele records the discussion she had with you in the presence of Mr. Zide about what happened at the insolvency inquiry, correct?
I don't understand your question. Can you rephrase it, please?
To try again. This part of the memo, paragraph 1, references the discussions that Judge Makhubele had with you and Mr. Zide, correct?
Yes, Chair.
And one of the issues that was discussed there related to the testimony that was given by PRASA officials at that inquiry, correct?
Yes, yes, Chair.
And what Judge Makhubele did at that point in time was to record a reference to those discussions in a document. And I'm suggesting to you that if ever there was any secrecy around those discussions, there would not have been a record of this kind that you now see in paragraph 1 of the memo.
I don't agree with that, Chair. I'm specific to the secrecy. I'm specific to the secrecy, and it relates to the settlement of this particular matter. The meetings we had, there was this, yes, we had, and she even says it was a brief meeting she had with me, talking to the nitty-gritty that speaks to the settlement that was entered into. I'm not speaking about these other issues. She was entitled to ask for information as I testified, Chair, which we provided.
Look at paragraph 2. I confirm receipt of a report from Prasa's attorneys, Diale Mokhasho attorneys, dated 21 November 2017. We'll get to that report in due course. It appears from the contents of the report that Diale Mokhasho attorneys were appointed to defend 5 civil actions that were instituted by Siyaya DB Consulting Engineering and Siyaya Rail Solutions at the Gauteng Division, High Court, Pretoria. The former, which instituted 4 of the actions, subsequently went into liquidation. The narrative recorded in that paragraph is correct, to the best of your knowledge.
It is correct, Chair.
Yes. And in paragraph 3, it is not clear from the report of Mokhasho Diale attorneys whether they were subsequently appointed to represent PRASA to deal with the liquidation matters. As acting group CEO, such instructions would have come from you. See that?
I do see, Chair.
Yes. And you read the Mokhasho report of 21 November 2017.
Yes, Chair. Yeah.
There is no reference to it about the instruction given to them to attend the liquidation 417 inquiry, correct?
Yeah, I think there is no reference to it, but
Yes.
we understood what we had instructed
Yes.
Mokhasho to do.
And the reports, paragraph 3 continues to say, as acting group CEO, such instructions would have come from you. Do you see that?
I do see, Chair.
And it would be correct to suggest to you that final accountability to the board in relation to instructing attorneys to defend or institute proceedings on behalf of PRASA rests with the group CEO.
I explained that, Chair, that the ultimate person who's accountable to the board is the group CEO.
Yes.
And in terms of the delegations of authority, matters are then subdivided as to who is to do what. So I can't dispute that he was
Yes.
the group CEO. And
So just to confirm with you, paragraph 3 in its entirety is correct to your knowledge?
well, I don't know whether I agree that such instructions would have come from Mr. Zide as the acting group CEO. If anything, they would have, the expectation at least that Mr. Zide would have had is that as the group legal department, we deal with this particular issue. But if that's what the chairperson, has understood, I can't dispute that, because the group CEO would have to be advised of, what it is that we're doing. So I can't dispute what she's written there. But from a practicality perspective, the group CEO was not instructing lawyers.
Chair, I'm going to skip paragraph 4, and I'll go to paragraph 5. You are aware that attorneys acting for Siyaya Consulting Engineering in liquidation approached, there seemed to be subtypo there, on or about 14 November 2017, and that they provided me with a copy of the interim report of the inquiry in terms of the Companies Act that was prepared by the Commissioner, dated 15 September 2017. Do you see that?
Yes, I do, Chair.
So, as a matter of fact, Judge Makhubele, in that paragraph, disclosed the fact that she was approached by the attorneys acting for Siyaya.
That's not what she said to me, Chairperson. That's what the paragraph says. This is her memo. That's not what she said to me when she spoke to me on the 14th. So I can't dispute this. I don't know. That's what she writes there. But when we had that meeting, she spoke to collegiality, and that's where she had received the report from.
Well, do you accept that she disclosed that fact in the memo?
It's there, Chair.
Yes.
I'm not disputing it.
And you have read that memo even on the 29th when you got it?
Yes.
Yes. So there's nothing secret about the fact that she was approached by the Yaya attorneys.
Chair, once again, I'm not going to labor on my point about what it is that I regard as secret. These issues, Judge Makhubele, although worded differently at the time, she did say to me, she's received the report. There was nothing secret about it. I asked for the report to see what was contained in the report, and she wouldn't give it. So there is nothing secret about this. I have said it. The secrecy that I'm alluding to is not in relation to these meetings that at least I was party to, and the reports that I had received and that were forwarded to her. It was in relation to the settlement agreement that was entered into. I have explained myself on that, Chairperson.
Can you recall when that settlement agreement was entered into? Do you know?
As I said, Chair, when it came to me for the first time, it was roundabout, it was at the beginning of 2018, when the CFO at the time approached. Because remember, Chairperson, what I gave evidence on is the fact that we inquired from Mr. Makhasha as to why he's not communicating with us. And his response that was to us, the chairperson has barred me from speaking to the legal department.
That was his response.
That was his response to
And
us.
he said that to you.
Yes, he said that to us, and this is the evidence I've given even at the State Capture Commission, and it's an evidence that he doesn't dispute, yes.
But at this stage, there was nothing secretive going on.
No, Chair. It was just fact-finding process, and we didn't have a problem with providing the chairperson with the information she required.
I think everybody will want to take a break.
Thank you, Chair.
Mr. Monteleca. Can we start again at 2?
Thank you, Chair.
Thank you. We will adjourn now until 2 o'clock. Thank you. Yes, ma'am, must remind you, you're still under oath.
Yes, Chair.
Yes, Advocate Maleka, you may proceed.
Thank you, Chair. Chair, we're dealing with paragraph 5, page 249, volume 8. Indeed. Ms. Ngoye, one of the persons who approached Judge Makhubele, acting as the legal representatives of Siyaya, is Advocate Botes SC. I take it that the name rings a bell for you.
Yes, yes, it does, Chair.
Yes. And Advocate Botes SC was also called to testify in the Zondo Commission. I take it that you are aware of it?
I'm aware he was called.
Yes. Now, he said some few things that I'd like to draw to your attention to see what your view is in that regard. And I apologize that I'm going to shift away for the time being from volume 8 and ask that you go to volume 19.
I've got volume 19, Chair.
And if you don't mind, could you please go to page 45?
I'm there, Chair.
Judge Mushida, I will read parts of volume 19, but as a matter of context, this is an affidavit made by Advocate Botes in response to a complaint lodged by Judge Makhubele against him at the Pretoria Society of Advocates. I suppose you don't have much knowledge about it.
No, I don't.
Yes.
Chair.
But what I wish to draw attention to is what Mr. Botes said in her response to the complaint at page 47, paragraph 8. And for the benefit of all concerned, I'm going to read out this. He said in paragraph 9, Judge Makhubele and I know each other since 1997. We served together on the Bar Council, and her integrity, dignity, ethical values, and honesty were never in doubt. Do you see that?
Yes, I do, Chair.
Yes. Do you hold a different view to that which is expressed by Advocate Botes?
In my dealings with Judge Makhubele, Chair, and what transpired, these were not displayed.
Yes. All right. And then in paragraph 10 of that affidavit, Mr. Botes quotes paragraph 9.1 of Judge Makhubele's statement of complaint against him. And he says, the liquidators approached me, first through Advocate Bottas, on about the second week of November 2017, followed by a letter towards the end of the month to intervene in a dispute that had ensued with regards to whether there was a need to proceed to arbitration in view of the evidence at the inquiry. And you will see that he deals with that part of Judge Makhubele's statement in paragraph 11.2. He says, it therefore came as no surprise to me when I received a call from Judge Makhubele on or about the first or second week of November 2017. Judge Makhubele phoned me on my cellular phone, and I immediately congratulated upon her appointment to the bench of the court. Let me stop there. Mr. Bottas suggested, also before the Zondo Commission, that the engagement between him and Judge Makhubele was initiated by Judge Makhubele. And Judge Makhubele denied that version. Do you know that the forensic investigators of the Zondo Commission investigated that issue?
No, I'm not aware, Chair.
And they made a finding around who initiated the contact from their forensic examination of the telephonic and electronic gadgets of both Advocate Makhubele at the time and also Advocate Bottas. Are you aware of that fact?
No, I don't know,
Yes.
Chair. I don't know about it.
The finding of the Commission in that regard is included as part and parcel of the documents that we got from the pro forma prosecutor. And Chair is in volume 7. And may I ask you to make a note that the critical part of the finding is at page 519, paragraph 19.3. And this is a finding of forensic investigators who had done their job by looking at the digital images of the electronic gadgets belonging to both. And the finding is to the following effect, paragraph 19.3. Judge Makhubele likely responded by calling Mr. Bottas on 13 November 2017 at 11.21. The call was 383 seconds, 6 minutes, seconds in duration. And as I understand, Mr. Bottas has not disputed that finding of the Zondo Commission forensic investigators. And I also ask you to look at that finding if you have volume 7 before you.
I've just received it, Chair.
Can you go to page 518? Under the heading conclusion.
Just please, can you bear with me, Councillor?
Yes,
Page 518.
yes. There are two numbers. One is in bold, that's the reference I'm relying on. The other, it's a faint reference, it's 441. But if you have the bold one, which seems to be the pagination that follows sequentially, you will see that there's page 518, and there at the bottom is conclusion, paragraph 19.
Sorry, Chair, we're just going to assist with the volume.
Yes, thank you, Chair.
I've got it, Chair.
You will see that under the heading conclusion, the investigator says, on the basis of what has been set out above, I respectfully submit that the following conclusions may be made about the initiation of communication between Judge Makhubele and Mr. Bottas in the first or second week of November 2017. 19.1. Mr. Bottas likely initiated the communication with Judge Makhubele on 13 November 2017 by calling her on 10:23. This call was 57 seconds in duration. The 10:23 call went unanswered and was forwarded to the voicemail box of Judge Makhubele's mobile phone number. And I've read 19.3 for you. So, in sum, this investigator concluded that it is Mr. Bottas who initiated the communication about the Siyangena matters with Judge
Siaya.
with
Siaya matter, Chair.
Siaya matters, my apologies, with Judge Makhubele. Do you see that?
Yes, I see what it's written here, Chair.
And I'm sorry to take you back to volume 19.
I've got it, Chair.
On page 51, paragraph 11.6.2, Mr. Bottas talks about the insolvency inquiry, which was set down for 5 days from 28 August 2017. I don't think much turns on that. And then he says a copy of the entire record, approximately 210 pages, is attached to Judge Makhubele's statement. And then in 11.6.3, it says Mr. Krige prepared a report on 15 September 2017 on a proper interpretation and analysis of Mr. Krige's report. It is evident that the witnesses, employees of PRASA, conceded the majority of the company's claims. We'll get back to that. I'd like to conclude my reference by asking you to go to page 52, paragraph 11.8. Judge Makhubele and I did not discuss the merits of the matters during our aforementioned meeting. See that?
Yes, I do, Chair.
And I have no I assume you have no reason to dispute this version of Mr. Krige.
I don't know. I can't say. I don't have, Chair.
Yes.
I don't know about it.
And then on page 53, paragraph 12.3, again, it is Mr. Bottas who's speaking. Judge Makhubele and I were on the same page insofar as honesty, transparency, and ethical conduct are concerned. Do you see that?
Yes, I do, Chair.
Yes. We have been informed by Ms. Zungu that Mr. Bottas will be one of the persons who testifies to assist the tribunal. But for now, and for the purposes of your evidence, if Mr. Bottas confirms his version, specifically in paragraph 12.3, that insofar as his dealings with Judge Makhubele is concerned regarding the Siaya matter, They were on the same page as far as the question of honesty and transparency is concerned. Do you see that?
Yes, I do, Chair.
And that also included the question of their ethical conduct relating to the CAR matter. I suppose that you would have no difficulty with or dispute what he will confirm when he comes to testify in that regard.
Yeah, that's his dealings, Chair, with the judge. I'm not sure what I'm expecting. I can't dispute what Mr. Bottas is going to say, obviously, in terms of his dealings with Judge Makhubele. I just can't, if
Well,
that's how
in some he
he
says that.
opined.
I'm sorry to interrupt you.
Sorry.
Sorry to interrupt you.
If that was his, experience, certainly from a transparency perspective, I wasn't afforded that opportunity, so it's his evidence. I don't know. Yeah, it is his view, Chair. I can't dispute it.
Yes. I've put volume 19 aside. Can I ask you to go back to volume 8?
I've got it, Chair.
I'm at paragraph 7 on page 250.
I'm there, Chair.
It is clear from the interim report of the Commissioner that the witnesses that testified at the liquidation inquiry include former and existing employees of PRASA. These witnesses would have attended the inquiry with your knowledge and understanding of the evidence that they were going to tender. 8, should the contents of the Commissioner's report be correct, it is clear that the witnesses made major concessions with regard to the liability of PRASA in the civil actions launched by Siyaya Consulting Engineers, now in liquidation. However, despite these concessions, Mohashwa Diale attorneys appear still to want to proceed with arbitration proceedings. They, however, did not address the prospects of success at the arbitration proceedings in view of the evidence that has already been led at the liquidation inquiry. Do you see that?
Yes, I do, Chair.
Yes. I take it that you have no issue with the fact that Judge Makhubele was entitled to inquire why this litigation was going on in the light of the evidence that was presented at the 4-1 inquiry chaired by Mr. Kriche.
I didn't have an issue with that, Chair.
Page 251, paragraph 9. Judge Makhubele says to Mr. Zide, kindly request the officials indicated hereunder, who testified at the liquidation inquiry, to submit written reports and confirm their testimony. A, Mr. Famelian, B, Mr. Kobue, C, Mr. Baltic. Once again, nothing wrong with that request by Judge Makhubele.
No, nothing wrong, Chair.
Yes. Now, I want to interrupt myself here by taking you to one of the reports that was submitted in response to Judge Makhubele's request. I believe that it's a response from Mr. Famelian. And Chair, the report is at page, so I said Mr. Famelian, I believe that it is Mr. Baltic. It is at page 257. The report is dated 30 November 2017. Do you see that? On page 258.
Yes, I do, Chair.
And I take it that after it was received by Mr. Dingizwayo, you had an opportunity to look at that report.
I don't recall having read the report. Was it sent to Mr. Dingiso? I'm not sure. Where is it referenced to be sent to Mr. Dingiso, Chair?
Well, we can go through the documentation through the long route. Fact of the matter is that once the chairperson prepared her memo that we're dealing with, she sent it to Mr. Zide, and Mr. Zide shared that memo with you on the 29th.
Yes, I've considered that.
And through you, Mr. Dingizwayo called for the relevant officials of PRASA who testified
Yes.
to prepare the report in order to answer the request of the chairperson. Correct?
Okay, my understanding was that what we asked, Chair, not my understanding, but what we asked them was to confirm whether they'd made any concessions
Yes.
at the 417 inquiry.
But via the reports, written reports requested by the chairperson.
I can't dispute that, Chair. You know, all these things happened.
Well-
Whenever they happened, Chair, I can't repeat. I mean, if it was sent to Mr. Dingiswayo, yes, it was sent to Mr. Dingiswayo. There's no basis for me to refuse that. I can't remember, Chair, if I've actually ever seen this letter. It's probably whilst we were preparing for the litigation, but I'll have to remind myself, Chair. Can I go through the contents and perhaps just remind what, and maybe something would trigger?
If you have a look at the letter, it seems to have been written on the 30th of November 2017,
Yes,
correct?
yes, Chair.
When would you have seen this?
30th of November. And then we go in, probably on the same day. I don't know, Chair. Yeah,
Either you remember or you don't remember.
I don't recall, Chair.
Okay.
Thank you, Chair. Can I, now that you're looking at it, refresh your memory about what that report said? And I recall that even from the affidavits of Mr. Dingizwayo, he confirms that he received these reports.
Okay.
And it says right at the top of page 257, this report has been requested by the chairperson of the PRASA Interim Board, Advocate T.A.N. Makhubele. Siaya Consulting Engineers, Siaya in parentheses, have been appointed by PRASA as technical advisor and supervision for Gauteng re-signaling project, Gauteng 2 re-signaling project, and radio digital railway signaling network project known as GSMR project. Makensa Mabunda was in leading Siaya. I, the undersigned, Soren Baltek, was charged by PRASA to direct these projects. See that?
Yes, I do, Chair.
So for PRASA, a person with the most reliable information about these projects and how they were implemented as a project manager, Mr. Soren Baltak will be well placed to talk on that issue.
Yes, he would, Chair.
At the beginning, Chair, I'm reading from unnumbered paragraph 3. At the beginning of the year 2017, PRASA have been informed that Sierra Consulting went into liquidation. On 28th August 2017, I have been subpoenaed to give testimony as witness to the commissioner appointed by the High Court of Pretoria. At the beginning of the inquiry, the legal representatives of Siaya gave an introduction and stated that they want only to establish facts in a transparent way. Do you see that?
Yes, I do, Chair.
Again, it's common cause that Mr. Brotes represented Siaya at that inquiry.
I understand that, Chair.
Yes. And Mr. Baltak confirms that what he was trying to do at that inquiry was to establish facts in a transparent way. Again, the theme of transparency that we have seen from his affidavit that I've read out to you. And he continues in that report, that is Mr. Baltak. In essence, I have been asked by the Commissioner to answer the following 3 questions regarding re-signaling projects. 1, did Siaya fulfill their contractual obligations? Can I stop there and take you to his answer in response to that question? You will see there's a subheading says my answers to these 3 questions were, and in response to the first question, his answer is 1. Yes, in my opinion, Siaya fulfilled their obligations before entering into liquidation. You see that?
I see that, Chair.
Yes. And I suppose you have no reason to dispute what Mr. Baltak has said.
Well, I'm amazed, Chair, because the instructions to defend the matter came from Mr. Baltak. I gave that evidence initially to say we don't just lead these matters because obviously we're not involved in the operations. So we would have to get the information from the business. Now, it becomes interesting that at the hearing of the 417, he says they performed. Whereas when we were dealing with the summonses and saying, is there a basis to defend these summonses? His answer was yes. So how, he decided to deal with these issues, we act on the instructions coming from the client. So, that's what he tells the commission, and this would be the issues that we had wanted to canvass, Chairperson. And as I said in my evidence, if we had had sight of reports that, or that report, Section 417 report, we could have looked at it and seen what was contained in there to see whether we, then change our minds around this particular matter. But our instruction from the business was that we have to defend these matters. PRASA does not owe Siaya monies.
Well, look, this report was commissioned by the chairperson. Mr. Baltak tells the chairperson, through a report that you requested him to make in response to the chairperson, that Siaya had fulfilled its contractual obligations before it entered into liquidation. Whether he changed his view or not is a separate matter. But the fact of the matter is that in that report, he records a fundamental concession around the issue between the parties. And I assume that if you had not seen this report, certainly Mr. Dingizoyo would have seen it.
Yeah, I guess that's correct, Chair.
The second question he was asked by the Siaya lawyers and the commissioner, Mr. Krugha, to deal with is the following. 2, have Siaya been remunerated for the work done? Do you see that?
I do see, Chair.
And the answer is, I was aware that there were instances when Siaya have not been paid for the work done. Do you see that?
I do see, Chair.
And I suppose that Mr. Baltak would have no reason to lie at all to the chairperson when he responded to that question the way he did.
No, there wouldn't be a reason. He was supposed to effect the payments, Chair.
Oh, yes. And he's the best person for the project who tells the chairperson that Siaya had done the work, but they have not been paid.
Well, that's what he said to the chairperson. It's not what he said to us. So,
The third question he was asked to deal with is the following. If there is any payment outstanding towards Siyaya. SLR produced a list of Siyaya unpaid invoices. Question mark. And the answer is 3. I need to look in the file and consult with my colleagues, Johan Edward, Chief Engineer Signal, in order to come with a reliable response. Do you see that?
I do see, Chair.
Yes. And then if you go to page 258,
I'm there, Chair.
at the top of the paragraph, furthermore, the SLR, through the Commissioner, asked if I know if there is any outstanding payment to Siyaya for the GSMR project. Why and what is the value of this outstanding payment?
I see
Next.
that, Chair.
My response was that there is an outstanding payment for a variation order. Siyaya have been asked to assist PRASA to get the most effective deal for the extension of the GSMR contract. The decision for payment has been stopped at higher levels in PRASA due to different opinions regarding the rates charged by Siyaya's German expert working on the project. In my opinion, the value of the VO, that's a variation order, need to be revisited and agreed. Do you see that?
I do see, Chair.
And in a long engineering way, this is a simple reflection of the fact that there is a money outstanding to Siyaya, but someone at the higher level of authority has stopped that payment, correct?
Well, that's what he says.
Yes.
But also going further, Chair, he says that this variation order needed to be revised and agreed. So I can't speak to those specifics. I mean, I think one understands how variation orders work. A client cannot implement a variation order until all the issues have been agreed. I don't know, you know, Chair, the reality is the information that we were given was that we don't owe CI. Mr. Soren Baltic himself, because when we consulted upon them giving us the summonses, we had to make sure that we don't just defend this matters if there is no need to defend. And that's how we approached litigation matters within PRASA, because sometimes we knew the business was just delayed in making, you know, the necessary payments, and we came across those quite often. So we needed to establish the facts behind it and get the evidence. And what we were given and told is that we do not owe CI, and therefore we needed to defend these matters. And that's why when Judge Makhubele asked me, I said, I'm hearing this for the first time because we have a good case to deal with from a PRASA perspective.
And who told you that?
Soren Baltic.
So what you are saying, that what's contained in this, let's call it, a memorandum or missive, seems to be contrary to what
Yes.
you were told.
I'm saying that, Chair.
Thank you.
Can we then deal with the remaining parts of Mr. Baltic's report?
Yes, Chair.
At the end of the inquiry, I'm reading the penultimate paragraph on page 258. At the end of the inquiry, I have been asked by the Commissioner to check with Mr. Johan Edwards the outstanding payment for re-signaling projects and to confirm what is the final value of these outstanding payments and to revert in a week's time. For the GSMR project, the Commissioner asked to consult and agree with Makhensa Mabunda the value of the VO and revert to him also in 1 week. You see that?
I do see, Chair.
So the Commissioner was quite concerned to fulfill his duties by resolving the issues relating to outstanding payments.
Yes, Chair, I see that.
And then he concludes his report as follows. After the testimony, PRASA Legal Department has instructed me not to enter any discussion with Mackenzie Mabunda or with the Commissioner. My involvement by now in this process was finished with his instruction, with this instruction. Again, I suppose Mr. Baltak has no reason to put an incorrect version when he said the legal department of PRASA instructed him to not enter into any discussion with Mr. Mabunda or with the Commissioner.
That's what he says, Chair. I mean, it's alarming. We understand, the insolvency inquiries, how they operate. I can't imagine. It's a pity he doesn't say who within the legal department. There's the entire department that told him that. He doesn't even attach anything to this that says, here it is, that comes from the legal department where this particular instruction was given. I don't think in our rightful minds, in our professional, the way I understand we work within the legal department, we would have given an instruction to say, do not cooperate with the inquiry. They went there, we knew about it, that they're there. And, why would we say they mustn't cooperate? I mean, it doesn't make sense to me. So that's what he says. I can't speak to it, Chairperson. But to suggest that the legal department said to him he mustn't communicate with the Commissioner or Mr. Mabunda, I'd like to know who in the department would have given him that instruction.
Well,
no, it wasn't me, Chairperson.
Well, and that's the point. This document is quite important on your view about whether PRASA was liable or not to the CIA group of companies. It's a vital document which was requested by the chairperson. It is a vital document which was produced in response to the chairperson's request. And you're telling the commission, the tribunal, that you did not see that document after it was produced in response to the chairperson's request. Chairperson,
I did explain, as a group executive of legal, Mr. Dingiswa perhaps can come and speak to this thing, as a group executive of legal, there were other things that one was involved with. And I think also there's a time where Mr. Zide does indicate that I was not in the office and Mr. Dingiswa must deal with certain matters. So it's not surprising for me not to have seen this particular report. I may have been involved elsewhere. But Mr. Dingiswa, as an executive, would be dealing with these matters, and I've got no reason to doubt his abilities. So I suggest perhaps maybe he can speak to it and explain his understanding, whatever else he then did after this report that he had received from Mr. Baltak.
But as far as you were concerned, PRASA didn't owe this money.
Yes, that's exactly what I said to the chairperson, even on the first encounter. I said, Chair, I'm puzzled because the understanding and the instructions that we have is that we don't owe CI, and therefore we must proceed and defend the matters.
And what was the response when you told the chairperson?
The chairperson obviously disagreed in light of the report she had sight of from the colleague that had given her the report in light of what's the word I'm looking for, the concessions that were made. And I think, Chair, for me, and that is why my approach was, Chair, share this report with me so that I can see what we're dealing with. Right now, I don't know, but the report was never forthcoming. So,
Would it be correct to say that around the end of November 2017, You had one view as to how the matter should pan out with CIA.
Yes.
And Judge Makhubele, who was the chairman of the inquiry, had another.
Yes.
Now, your impression as to how the inquiry against, or how the litigation against CIA should proceed, what was that informed by?
It was informed by the information that we had received from the business unit in terms of the specific projects
Yes.
that they were responsible for. And they were able to say to us, this is what we have. We don't owe CIR this. We are disputing these matters. Let us go and defend these matters and let them prove their claims.
And who would be that person?
From the PRASA technical, there were two areas.
Yes.
PRASA technical side, we dealt with the group executive there, which was Mr. Kevin Monsami, together with the manager that was dealing with the project, which was Mr. Kobue. And then from the strategic asset development side, the group executive there was Mr. Pete Sebola, and Mr. Soren Baltic reported to Mr. Pete Sebola. So when we prepared the defenses, you know, we had all these people at one point in consultation with them to say, give us, you know, exactly what has transpired here. Because as I explained, Chair, we didn't just want to defend any matters unnecessarily. And we were not opposed to settling matters. You know, we found the need to settle.
But what you received from them at this meeting, when was that meeting?
This would have been at the time of after the summonses were issued.
And it would appear to you that PRASA should defend,
Yes, Chair.
whereas this correspondence seemed to suggest something else.
Yes, sir. Yes, Chair. That's why I am, you know,
Yes, thank you.
quite surprised.
Chair, can I ask for an indulgence, just to take 5 minutes adjournment to take an instruction from Judge Maluleke?
Yeah, certainly.
Makhubele, sorry.
We'll be waiting
Yes.
for you.
Chair, thank you very much for the indulgence. Ms. Ngoye, we were exploring the last part of Mr. Baltak's report when he indicated to the chairperson that he was instructed by someone in the legal department not to enter into the discussions requested by the chair of the 417 inquiry. And you confirmed that you did not give that instruction.
No, I didn't give the instruction, Chair.
And you also indicated that you don't know who gave the instruction, if any.
I don't know who gave who would have given that instruction, Chair,
Yes,
if any.
yes. But on the face of it, either Mr. Baltak is telling the truth or he is not telling the truth, in which event he would be misleading the chairperson.
Yes.
We will argue later what the body of the probabilities should lie. But
Sorry, Counsel. May I make reference to the memo that Mr. Dingiswayo prepared? I don't know if I can, but it's here, it's in the bundle.
yes, yes,
Just to highlight,
yes.
you know, the importance of dealing with these matters and what one understands. On page 262, Chairperson, Mr. Dingiswayo, you will note, Chair, it is just from Mr. Dingiswayo to Linda Kayazide. I'm not copied on
I'm sorry.
on this.
I'd
on
like
this.
to follow, Chair, if I may go to
It's
page
page 249, Chair. It starts there. It's still on volume 8, the volume that we've been dealing with, Chair. 259 is the page.
It's 259, I think.
Can I proceed, Chair?
Let them. Just want to get clarity on this document you're referring to. Is this the one from Mr. Dingiswayo to Mr. Zide?
That's correct, Chair, that's the one.
And it's at page 259 of volume 8.
That's correct, Chair.
Thank you.
Can I proceed, Chair? On page 262 of the report, of the memo, I've noted that Mr. Baltak's report basically deals with a GSMR project that he was alluding to in his report to the chairperson. In that, Mr. Dingiswayo's memo, he says, a consultancy in respect of GSMR is clause 2.4.3.5. Sub 1 thereof says, PRASA denied the conclusion of the agreement for additional services. In the alternative, and should it be found that such an agreement was concluded, PRASA denied that Mr. Soren Baltak, who is alleged to have represented PRASA, was duly authorized to conclude the agreement. Now, that's the information that we had received, and that's why the response was given in terms of the defense that we had. And then it says, the report that was submitted by Mr. Soren Baltak to the chairperson is consistent with the above main and alternative defenses. In his report, Mr. Baltak indicates that there was a disagreement about the rates of professionals employed for this additional work. He specifically states that he indicated to the commissioner that in his opinion, the value of the VO needed to be revisited and agreed. Because at the time when this particular instruction was given to us, it was clear that, and that's why I spoke to variation orders, in terms of the agreement was specific as to how variation orders needed to be dealt with. The supplier couldn't just proceed without having received written confirmation from the client to proceed. And this was the basis of defend these matters, because these issues were never finalized, and CIA had just gone ahead and proceeded to do this work. So that's the understanding that we had at the time, and that's why we proceeded to defend the matter. So when he goes to 417, to writing the report of the chairperson, he phrases it in the manner that he does. And he also alludes to the fact that he needs to still go and consult with one of the other engineers to establish the full information. So,
Just wanted to get clarity on this. We have the report from Mr. Dingiswayo now.
yes, Chair.
And we have the report written by Mr. Baltic.
Yes, Chair.
The two don't seem to gel. Do you understand?
They don't gel, Chair. They don't gel.
What was your understanding of the position then?
The initial understanding that I had was there was no agreement in relation to the variation order that was proposed in relation to that specific agreement. And that CIA, without those issues being finalized, proceeded to do work and then came back and asked for payment in respect of that work. And obviously, in terms of the agreement, there was a specific way in which variation orders must be dealt with. And that was not complied with by CIA. Now, as to whether, PRASA now could be expected to pay for those services that it did not necessarily require, that's where the dispute was, because there was never agreement to say proceed with this variation order and conclude the work. And that's why also, Chairperson, we understood that to be the instruction and the defense at the time. And also from Mr. Kobuwe's side, when we spoke to him, it was the same issue.
Thank you.
Can I ask you this? The report of Mr. Dingiswayo is dated 30th November 2017.
That's correct, Chair.
You said, as at that date, you did not see the report of Mr. Baltic. Did you see this report of Mr. Dingiswayo on the 30th of November?
I had not seen it, Chair. I had not seen it, and perhaps it's just a document that I saw later. Because as you can see, I'm not addressed in that communication. He addresses it directly to Mr. Zide.
Yes. And so your evidence at best with reference to the paragraph you have referred to under the consultancy agreement on page 262 is based on something other than the documents which you did not read as at the 30th of November 2017.
Well, Chair, from my knowledge of this matter and the instructions that we had received right at the onset, I think I'm able to then say, clearly what is contained in here. There may be services that were rendered, but was PRASA liable for those services? That I can say. The instruction that we received was that they were not. So these reports come in afterwards, and I'd not seen, obviously, these reports that came in. But my understanding was that there was non-compliance with the contract, and therefore there was a dispute around the services that were rendered, as well as the amounts that needed to be paid in relation to those. So let's go clock this thing out and prove your case, and we proceed. So,
You know, Mr. Baltak is an employee of PRASA, a senior engineer who is a project manager on these contracts. And he speaks on matters. He speaks on matters that are within his personal knowledge. Can you think of any reason that he would tell you one thing and goes to tell the person something else relating to liability, which he believes PRASA has to CIR?
well, there's been many inconsistencies, Chair, that comes from a character of Mr. Soren Baltic, having dealt with him. So I'm not surprised that this is the scenario. I know Mr. Baltic, I've worked with him. And his character can be assessed in the manner that is required. But I know that there would be a number of occasions. That's why we needed Mr. Pete Sebola to actually be in there as well. That's why we needed the executives of these project managers to be in there as well when these instructions were given.
You know, you were asked questions about this by Ms. Zungu when she dealt with the question of the concessions made at the 417. And if it's necessary, we will look at the transcript. But when you were asked question by Ms. Zungu on that score, she went through each and every person who testified at the inquiry. And your response was you were not surprised that Mr. Lucky Montana and I think it was Dr.
Tim Kulu and Mr. Maishe.
Dr. Tim Kulu would have made the concessions. But the others, you were not prepared to accept that they would make the type of concessions that were reported in Mr. Kruger's 417 report.
Yes, I wasn't prepared to, Chairperson. And as I indicated, again, the instructions that we were given did not make sense, then therefore, for these concessions to be made then at the 417. Because we're not just doing this and fighting matters on behalf of PRASA for the sake of it, So it was surprising for me that Mr. Soren Baltic would have conceded. It was surprising for me that Mr. Kobue would have conceded when they were part and parcel of the briefing meetings, So I was very clear about that. And that's why I even said to the chairperson, if we can see that report and see what was said, we'll engage further within the organization to establish what has happened. And if we really don't have to proceed with the matter, we wouldn't, just for the sake of it.
We have read that report of Mr. Dingizwayo. He does not deal at all with that part, the concluding part of Mr. Baltic's report, that legal department gave him instructions not to engage further.
Yes, it doesn't.
That is an important part of Mr. Baltic's report.
Yes, it is, Chair.
And he imputes an instruction which you take issue with to your department.
Yes, I do, Chair.
And Mr. Dingizwayo read Mr. Baltic's report. And he does not deal with that part of the imputation.
Yes,
by
he
Mr.
doesn't.
Baltic.
It's not here. Let's see. No, he doesn't deal with it anyway, Chair, from my quick squiz at this.
Yes.
He doesn't.
I may be wrong, but we have read it, Chair. We doesn't deal with it at all. And I would have thought that your department, comprising more than one lawyer, faced with Mr. Baltic's imputation, would deal with that issue head-on.
That's the expectation I would have had, Chair, and Mr. Dingiswayo will speak to that. I mean, I've been given evidence here and made to read stuff that I've got no knowledge of, you know, and let him come and speak for himself as to why he did not see the need to deal with that aspect of Mr. Soren Baltek's report.
Chair, I'm going to give you references, and I'm not going to waste time on this because it's something that in due course, if given the opportunity, we would like to draw your attention to. It is volume 8, page 253. It's a trail of email beginning from the middle. And the first email is from Mr. Dingiswayo to a number of people. And, well, 253 is to Mr. Kubue, and 254, it is also to Mr. Baltek. And it is his request that these individuals should prepare reports in response to the chairperson's request in her memo of 28 November 2017, especially paragraph 5 thereof. And both of them confirm in an email to him that they will prepare the reports concerned. Can I take you back to the chairperson's memo of 28 November 2017?
I've got it, Chair.
Paragraph 10 on page 251.
I'm there, Chair.
The chairperson says to Mr. Zide, please advise Makhubele attorneys that I have read their report dated 21 November 2017 and that we shall revert to them before the end of next week with an instruction and decision on further handling of this matter. 11, lastly, it appeared from the discussions in the presence of Ms. Ngoye that she was aware of at least the fact that there was a liquidation inquiry, kindly requested to write a report about the involvement of her unit, in particular with regard to provision of instructions to Makhubele attorneys on the issue I have raised above. Do you see that?
Yes, I do see it, yeah.
And I suppose that you would accept that the chairperson exercising her fiduciary duties was entitled to ask you to prepare a report in that regard.
I've never disputed that, Chair. I've always said the chairperson had a right to know information, you know,
Yes.
on matters.
And she requests that, well, let's read paragraph 12 together before I ask you a question. The reports from you, Ms. Ngoye, and the officials indicated in paragraph 9 must reach me on or before 12 on Friday, 30 November 2017, to enable me to report to the Board of Control on 1 December 2017. Do you see that?
I do see it, Chair.
Yes. It is not as if the chairperson was raising this issue for her own interest, but she was raising it with a view to report to the board on these issues, correct?
Well, that's what she says in her memo. In her memo, that's what she's writing
Yes.
to Mr. Zide.
And you did not go to the chairperson and say that that is not the purpose for which you're seeking these reports, did you?
No, I didn't, Chair. The chairperson was asking for reports like any other chairperson would ask for reports on matters. You know, it was not the first time that we encountered a chairperson requiring specific information on a matter, so.
And she's telling Mr. Zide, and through Mr. Zide, you know that she is requesting these reports for the purposes of reporting to the board at a contemplated meeting of 1 December 2017. See that?
That's what yes, that's what's contained in that memo.
And we know as a fact that that meeting took place.
Yes, we do know, Chair.
Now, the one thing I'd like to conclude on, in case I do forget about this memo, is that the chairperson is asking these questions through this memo, through the proper governance channels of the acting chief executive officer, Mr. Zide.
I have no dispute on that, Chairperson.
And she's asking Mr. Zide to report to him through gathering the reports she requested from a number of people, including you.
Yes.
I've spoken to Judge Makhubele on this issue. And she has a number of emails that she has just shown me quickly. And I'd like to present those emails tomorrow to the Commission, which indicate that after he received those reports, he called for a number of meetings in order to report on this issue in the light of the reports that she got, amongst others from Mr. Balchak. How do I scroll? Where do I start?
She called for what?
For a meeting. This one. And one of the emails, Chair, will make them available tomorrow to the Tribunal. One of the emails from her was 8 December 2017. It was addressed to Mr. Zide in her capacity as the acting group CEO. It says, please arrange a meeting for me with the internal auditors and LRC today to finalize this matter. I suggest 1400 hours. What is LRC, to your knowledge?
LRC, well, the legal risk and compliance.
That is you.
That is our department, yes.
I will also update you on the meeting I had with Council yesterday, as agreed with Mr. Mukhashwa last week. However, PRASA's representative did not attend. I mean, there's an email which is written on 8 December 2017. From your side, was she within her rights or properly fulfilling her duties when he asked Mr. Zide on the 8th of December 2017 to arrange a meeting, amongst others, with internal audit on this issue?
No, Chair. I don't dispute that she couldn't have called for that meeting. As far as internal audit is concerned, perhaps maybe I don't know the basis thereof. But she's a chairperson of the board, Chair. She can ask for these meetings to get clarity on matters.
Yes. And then,
No, I can't remember being asked that the chairperson has asked for the specific meeting. I don't recall, Chair. But if I wasn't available, definitely Dingiswaya would have gone.
and Mr. Zide respond, the subject matter is Ray Balchak's report, Siaya in liquidation. Date 8 December 27, time 8:27, 37 seconds AM, South African time. To Tinswalo Makhubele, dear Chairperson, indeed the meeting will be arranged. I will check with LRC. They had advised that today they were to have a Christmas lunch as a department. See that?
I don't see it. I don't know.
Well,
You're reading from it.
You heard that?
I heard it, yes.
And I suppose that Mr. Zide would have recorded the facts as he knew them, that you were having a Christmas lunch as a department on the 8th of December.
It's possible, Chair, that was the case.
Chair, we will produce these emails for the tribunal. What I'd like to do to see how this matter progresses forward, after the report of, amongst others, Mr. Baltic was given to the chairperson. Now, what I want to do in that regard is to keep you at the same volume. Eight. Chair, to facilitate matters, I have done a cross-reference, and I'll give it to you as we go along. But what I propose to do is for you to have page 272 up to page 274, my apologies, with you. At the same time, cross-reference page 233 of the same bundle. I think this will facilitate matters. Instead of me starting with the Mokhashwa report and then coming back to this letter on page 272. Where we would like to start, Chair, is to confirm with Ms. Ngoye that page 272 to 274 is the letter of Mr. Zide, which is dated 15 December 2017. Do you see that?
I do see, Chair.
And this letter is addressed by Mr. Zide to Mr. Mokhashwa.
Yes, I do see, Chair.
Yes. And if you go back to page 272, you will see that Ms. Zide starts with paragraph 1, saying, I confirm that you were instructed to defend the actions instituted at Gauteng Division of the High Court under case numbers indicated hereunder. Do you see that?
Yes, I do.
Furthermore, I confirm the meeting held between yourself and the chairperson of the Interim Board of Control on 15 December 2017, that you were instructed as follows. Do you see that?
I do see, Chair.
And it says, A, Sierra DB Consulting Engineering now in liquidation. In respect of case number 74281/15, process instructions are that you penned both the file and the arbitration proceedings until receiving further instructions. You are also instructed to confirm with the liquidators that the amount claimed by Siyaya, according to the documents attached in the particulars of claim, the matter appears to arise from an initial contract of 5.6 million, which appear to have been settled. The total amount for the project is indicated as 14 million. In this regard, the outstanding amount, if any, will be the difference between 14 million and 5.6 million, which Siyaya conceded in a memo provided to PRASA to have been paid and received. Do you see that?
I do see, Chair.
Now, again, you will confirm that Mr. Zide was, at this point in time, an admitted attorney of the High Court.
Yes, I think he is, yes, Chair, he is.
So he is a lawyer like you, and he will understand the implication of what he writes, especially when it comes to instructions to attorneys. Correct?
Chair, Mr. Zidi had never briefed attorneys in my experience, so he is an attorney, and he can write as best as possible, I guess. I'm not sure how I can comment on that when he had never done it
No,
before.
You can comment. He was an admitted attorney of the
He
High
was an admitted attorney, Chairperson, but it doesn't mean that I know how it is that he would deal with lawyers and whether he would be aligned with.
No, but he would have,
the thing.
like you, served articles of clerkship.
I think he did, Chair. For him to be admitted, he would have had to serve articles of clerkship.
And part of the training he would have received as an article clerk, as they used to be called, now candidate attorneys, would be to deal with briefing relating to counsel. It's part of the training which a CA receives.
It is, Chair, but I can further say Mr. Zide understood the policies within the organization. He did. And those policies were approved by the board. But in this regard, he chose not to comply with those policies, and he had a legal background. So.
Chair, can I ask you to cross-reference 272, paragraph 2.1 with 239, paragraph 2.3.1. Ms. Ngoye, if you go to paragraph 2.3.9, keeping at the same time open page 272, you will see that in 2.3.9,
Sorry, Chair, which document is that? That has 2.3.9?
are you at,
I've got Mr. Zide's letter.
yes.
That does not have 2.3.9.
No, I'm sorry to do this to you. Keep page 272, paragraph 2.1 open,
Yes.
if you can.
Yeah.
At the same time, cross-reference page 239.
I have a Chair.
Yes. We now know that page 239, which begins at page 233, is that report of Mohasho attorneys dated 21 November 2017.
That's correct, Chair.
And at page 239, 2.3, Mohasho attorneys deal with case 74281. This is the same case number that is dealt with by Mr. Zide in his letter of instruction at 272.2.1. You see that?
Yes, Chair.
And in it, from paragraph 2.3.1, going forward, Mohasho attorney analyzes the history of the instructions, the amount claimed, and the status of the matter. The point is this, that when you look at the report of Mr. Mokhashwa of 21 November 2017, and you look at the instructions that were given to him in relation to that matter, there was no instruction that they should settle that matter. The instruction was that they should pend that matter.
Yes, Chair.
I have looked at the correspondence that flowed after the arbitration. My understanding is that this matter was not settled at all by PRASA. Would that understanding be fair in the light of the correspondence that flowed thereafter?
Settled by PRASA, is it before the engagement of the chairperson or before?
At the arbitration that was before Justice Brandt,
None of the matters were settled, Chair, that we were dealing with in litigation. There was no settlement of those.
all right, that's your version, but let's look at page 273, paragraph 2.2. In respect of case number 77383/16, you have advised the chairperson that you did not file a plea because it was agreed between you and Siyaya legal representatives that the amount claimed under this matter was paid in April 2016. Do you see that?
Yes, Chair, I do see it.
Chair, can I ask you to cross-reference paragraph 2.3 with page 244 from paragraph 2.6? You will see that on page 244, 2.6, in his report of 21 November 2017, Mr. Mokhashwa deals with case number 77333/215. I have looked at the case number, is self-evidently incorrect because it is case number 77383/15. But the issue is not so much about the incorrectness of the case number, because what Mr. Mokhashwa deals with from paragraph 2.6, it's the same matter which Mr. Zide deals with in paragraph 2.2. You're welcome to look at it and tell me that you take issue about the typographical errors relating to the case number.
I don't, Chair, I don't. I mean,
Yes.
if it's a typo,
It's a typo indeed.
it is a typo.
Yes. And if you go to page 245, paragraph 2.6.8, when Mr. Mokhashwa reported to the chairperson in his report of 21 November 2017 about that case, he said the following, and I quote from paragraph 2.6.8. On 13 April 2016, we received correspondence from our opponents who informed us that their client had been paid in full the amount that they were claiming. And it's supposed to be proposed, but it's typed as prosed, that the defendant tendered the costs of the proceedings, We thereafter sought instructions from client to no avail. Do you see that?
I do see, Chair.
Yes. So on the report of Mr. Mukhasha that he gave to the chairperson, that claim was already settled on the basis that payment had been made already.
Well, Chair, if payment was settled, there was no plea that we filed to defend the matter, and state what it is that we were defending. So I guess it followed that basically from looking at the evidence that was given before us, that it could have been, I don't know, that the matter was paid in full. The reality is that we received summons in relation to this. Maybe the parties acknowledged that they had been paid. I don't know. I'm not going to speak to specifics. As I said, I received reports of what happened. So
Let's just get clarity on this. This litigation has been referred to now. When you read, and I take it that you read Dale Makhubele's attorney's report.
Yes, Chair.
The litigation that's referred to at paragraph 2.6.8, as far as you were concerned, it had been settled before.
It was done, yes, because I think the parties had realized that there was no need perhaps maybe for the summons to have been issued, and therefore no need to enter a plea.
Yes.
And that's why I was saying, Chair, we don't defend matters when it's not necessary to defend.
Just one concern with this thing. You have settled it before, but you nevertheless got a summons when they're suing for this.
That's the understanding that I had, that they were paid, but we got a summons
Yes.
in relation to this particular matter.
Yes.
Yeah, and that's why the defense was we don't owe them.
I see.
Yeah.
Yes.
My question was a little different, if I may explore it again. Because at the end of paragraph 2.6.8, Mr. Mukhasha says, we thereafter sought instructions from client, which is PRASA, to no avail. Do you see that?
Yes, I do see it, Chair.
And then in paragraph 2.6.9, well, let me stop here first. Let me ask you this. In the ordinary course of events, on the understanding of how external attorneys such as Mr. Mukhasha would deal with PRASA, your department will be the one that would give him instructions about this issue of costs.
Yes, together with the respective division.
You will be the one who interface with Mr. Mukhasha about the issue of costs.
Yes, Chair, we would, as the legal department, we would interface, but we don't just take that decision ourselves, and maybe this is what I want to express.
And in paragraph 2.6.9, he says, we on 13 June 2016 addressed a letter to PRASA to advise that we still await their instructions regarding tendering costs of this matter, and that we will proceed to render our invoice and close the file, as there was no longer any notable activity on the file. Right?
Yes, Chair, I see that.
And so he is still waiting for instructions from your department about the question of the costs.
Yes. I mean, the costs obviously became an issue to be considered, and why, as the defendant, we were required to pay the costs of that is not coming out clearly from this. Because if the matter was not even pleaded, Chair, we didn't see the need to defend it because we acknowledged that, these obviously clearly monies were paid and so on. The services were rendered in relation to this one, so there was no need to fight this matter. So why would we tender costs in respect of that?
Now, the question is a bit different. Why did you not give Mr. Mukhasha instructions on the question of costs?
I can't respond to that. That question was not directed at me. Mr. Mukhasha knows who he was dealing with at the time, Chair.
Can I take you back to page 273? paragraph 2.3. In respect of case number 73934/15, the amount claimed is 7,098,481.66. Process instruction is for the settlement of this matter as per the amount claimed. Do you see that?
I do see, Chair.
Chair, may we ask you to cross-reference that paragraph with 233 from paragraph 211. In fact, that is the first matter that Mr. Mokhasha deals with in his report. And if you go to page 235, paragraph 2.1.5, you will see that Mr. Mokhasha deals with the amount claimed, which is exactly the amount that Mr. Zide referred to in paragraph 2.3. Do you see that?
Yes, Chair.
And then from paragraph 2.1.9 up to paragraph 2.1.11, Mr. Mokhasha deals with the defenses that were raised in the plea. Do you see that?
Yes, Chair.
There's no need for us to reflect on the defenses at this stage. But the point of the matter is you'll see that Mr. Zide instructs Mr. Mokhasha to settle that amount in full. Do you see that?
I see that, Chair.
Yes. And then if you go to paragraph 2.4 on page 273, you will see that Mr. Zide says to Mr. Mokhasha, in respect of case number 73933/15, the amount claimed is 8 odd million. Process instructions is for the settlement of this matter as per the amount claimed. Now, Chair, may we ask you to cross-reference that part of the instructions with page 236? Paragraph 2.2. And I ask you to go to page 238, paragraph 2.2.7. Mr. Zide is dealing with process defenses. Are you there?
Yes, I'm there, Chair.
And at 2.2.7, it says, on 26 June 2016, the defendant served its plea, which was at the time a bad denial plea. You see that?
Yes, I do.
Yes. And it says, on 20 March 2017, the defendant amended its plea by replacing its previous plea of 26 June 2016.
I see that, Chair.
2.2.8, the amended plea raised the issue of jurisdiction in that clause 19 of the agreement upon which the plaintiff relied upon provides that the dispute between the parties must be referred to arbitration, and that the present dispute had not been referred to arbitration. Do you see that?
I do see, Chair.
And then 2.2.9, the defendant also denied that the agreement was entered into by its chief executive officer, as well as the correctness of clause 3.2 of the agreement. Lastly, 2.10, the plea also alleges that the defendant is not liable to the plaintiff due to the fact that the plaintiff failed to provide it with an occupation certificate as contemplated in clause 1.11 of the agreement. And so it goes on. Fact of the matter is that this is one of the claims which Mr. Zide notified Mr. Mukhasha in paragraph 2.4 that they should be settled, correct?
Yes, Chair.
Yes.
That's what he said.
And then the second last claim is the one dealt with in paragraph 2.5. And Chair, here too, we would ask you to cross-reference the instructions in paragraph 2.5 to page 241. From paragraph 2.4.1. And for the present purposes, I ask you, Chair, to consider what Mr. Mukhasha says in paragraph 2.4.6. It is a consequence of these services rendered, as well as the rejected variation orders, that the plaintiff now claims an amount of 15 odd million from the defendant. And then over the page in paragraph 2, page 242, from paragraph 2.4.7, Mr. Mukhasha deals with the pleas that he prepared as instructed. I'm not going to ask you to deal with what he said in that regard. All I want you to confirm is that that is a claim on which Mr. Mukhasha was given instructions in terms of paragraph 2.5 on page 273.
Yes, Chair.
The last claim I'd like you to consider is the one on page 273, paragraph 2.6. In respect of case number 47597/16, the amount claimed is 21 million. However, after investigation and verification, process instructions are that the amount that is due and payable for settlement is 19 odd million rand, including VAT. Do you see that?
Yes, I do.
Yes. Chair, may we ask you to cross-reference paragraph 2.6 with page 242, paragraph 2.5, and you will see on page 243, paragraph 2.5.7, there is reference to an amount claimed of 21,662,000 rand, 138 rand. Do you see that?
Yes, I do.
Yes. And the instructions from Mr. Zide is that the settlement should be at approximately 19 odd million rand. Do you see that?
Yes, I did see that.
So the claim was not settled in full, but was settled at a substantial amount, having regard to the amount claimed.
Well, that's what he's instructed.
Yes, yes, yes. And lastly, there's a question of interest, and I'm at paragraph 2.7 on page 273. It was noted that in some instance, in the summons instituted, the interest claimed was to be reckoned from the date of invoice. 2.8, the instruction to you is that the payment of interest should be reckoned from the date of summons. You see that?
I see it, Chair.
Yes. And then over the page 274, you are instructed to tender this offer as follows. 2.9.1, liquidators of Siaya, DB Consulting Engineers, now in liquidation, in the total amount of 30,576,171,000.53 plus interest.
I see it, Chair.
2.9.2, attorneys representing Sierra Rail Solution in the total amount of 19,583,778 rand and 42 cents plus interest. Do you see that?
I do see it, Chair.
And lastly, E, confidentiality clause. As discussed with the chairperson, you are to include the confidentiality clause in the settlement offer. You see that?
I do see it.
And he signs that letter on the 15th of December 2017. And that letter was received by Mr. Mokhasha on the 15th of December, same day at about 7:41 p.m. And if you go to page 275, you will see that Mr. Mokhasha writes to his counterpart representing Siaya, and he makes an offer to them consistent with his instructions. And in that email, he says, "Good evening, sirs. Attached are offers in respect of matters with case numbers," and he mentions them. And he says, "Kindly obtain instructions from your client and revert." Do you see that?
I do see it, Chair.
Yes. Now, we don't have the text of the offers he made, but for now, that is neither here nor there. At page 278, on the 18th of December, Matopo attorneys respond with a counter offer of their own. And you can look at the letter if you want to. The simple point I'd like to make for now is that if you go to page 279, paragraph 9, you will see that their counter offer is set out from paragraph 9 onwards. You see that?
Yes.
I have taken you to these documents simply to show you that the discussions about the settlements, offers and counter offers, were recorded in writing, as between Mr. Zide and Mr. Mokhasha, and as between Mr. Mokhasha and his counterpart, Matopo attorneys. Do you see that?
I know that. That's what happened, Chair.
Yes. And there was nothing secretive about these offer and discussions, negotiations, and settlement.
Well, Chair, I wasn't party to those discussions. What I know is that if that was the case, right, there would not have been a letter or as part of the settlement agreement that says PRASA accepts no liability. Why would you say we accept no liability, but you agree that these settlements must be entered into? It just doesn't correspond. So I actually don't know what transpired that Mr. Zide gave these specific instructions to Mr. Mokhasha to deal with. and Mr. Motapo seems to have known what the initial instructions were from Mr. Zide to Mr. Diala Makhashwa. That would have, for me, would have been an internal document that was given to Mr. Zide. So I don't know, I can't remember if he says he attaches, let's see. Kindly obtain office in respect of this. Kindly obtain instructions. I don't even know whether he had attached that letter that Mr. Zide had said attached to, that he had sent to him, because Mr. Makhashwa, in clause 3 on page 277, says, your client PRASA did not instruct you to submit an offer to tender to our clients in respect of the capital amounts only. So I don't know where he gets that information from, because Mr. Makhashwa would have sent through the settlement offer, as instructed to do. So how it is that Mr. Makhashwa knows that it was not capital only, I don't know. Your client's specific and express instruction to you was to submit an offer or tender to our clients which provides for payment of interest a temporary at the rate of 9% per annum, calculated from the dates upon which respective summonses were served on your client. Now, I'm going to just try and look at Mr. Zide's letters to Mr. Makhashwa. You are instructed to tender this offer as follows: liquidation, liquidators of CIA, right, in that amount, plus interest. Attorneys representing CIA Rail Solution, the total of plus interest.
Yes.
I'm just going through this. Please give me an opportunity.
Do you know anything about the instructions?
No, I don't.
No, wait, let me put the question. The instructions to settle these matters, do you know anything about it?
No, I don't, Chair. We were not part of this.
You were not part of it?
No. We were not part of, not at all.
Yes.
Suggest to you that the fact that you did not know about this does not make the settlement secret at all. That you are not aware of it does not make this secret. We have gone through documentation which record it.
And I say again, Chair, if we were party to this, because we were the people that were dealing with this matter, Mr. Zide was not. Mr. Zide was not dealing with these matters in his personal capacity and understanding, not even his area was dealing with these matters. And if an instruction is given to finance that says we do not accept liability, how is it that instructions are given to settle? This is a state-owned enterprise we're talking about. How is it that instructions are given to settle that speaks to the fact that we do not accept liability? Where does all this come from if we do not accept liability? I don't know. And these were things that were ringing in my head to say, because I'd not seen this correspondence from Mr. Zide to Mr. Makhashwa. So when the letter comes in is that we don't accept liability, pay this amount of money. What does one make of that? We are the group legal function. We have to advise the organization on matters of law and on other many matters. Now, if a document that gets drafted without our knowledge says you don't accept liability but pay, what is it that we're supposed to say? To say just go ahead and pay? We couldn't say that, Chairperson. And this is the reason why the policy of PRASA indicated that no one may communicate with external lawyers without the involvement of the internal legal department. It said that, and Mr. Zide understood that. But he went ahead and and did these things and not in compliance with policy. So I'm just dealing with what came before me, because as far as these settlements were concerned, we were not party to them.
When
Chair.
did
But
you
then,
first-
sorry,
No, ask your question.
I don't understand some of these things. On the one hand, there are instructions to fight the matters. On the other, there are instructions to defend the matters. And you know nothing about the instructions.
I do know the
To
instructions.
defend.
I know the instructions to defend. I don't know the instructions to settle.
Yeah. But did you find out or go to Judge Makhubele and find out what's happening here? We're now moving in two directions opposite. And
Chairperson, I mean, I
what's
did give,
happening? What should I do?
I did say I had requested to have a meeting with the chairperson. I can't just barge into the chairperson's office and say, I want to meet with you on this. And that meeting was never, I was never afforded the opportunity to discuss these issues with the chairperson. I mean, that's why I even said, just before we went to court, on the 8th of March, I knew the chairperson was sitting in the other room. Again, requesting, can I speak to the chairperson about this? And Mr. Cromet Molepo would not let me speak to the chairperson about these issues. So it's not like we didn't inquire before this in any event, because we understood the policies. That is why Mr. Dingiswayo and myself phoned Mr. Mokhashwa to say, what are you doing that we are not involved in this thing and you understand how things are supposed to work? So when his response to us was, I am barred from speaking to you by the chairperson of the board, we left it at that.
Now, in your view, who was giving instructions to Mr. Mokhashwa?
Well, the letters come from Mr. Zide.
Yeah.
He was clearly having consultations with the chairperson on this particular matter. That fact we knew, that Mr. Zide was involved in all the meetings that the chairperson of the board had with Mr. Mokhashwa in relation to the settlements of this. And that's why he could give this specific instruction to Mr. Mokhashwa.
You inferred that, or you have evidence
It
to
followed.
confirm?
It followed, Chair. We do know that Mr. Zide was part of those meetings, because, I mean, these are discussions we would have as colleagues.
I leave it there for now.
Thank you, Chair. No, Chair. Thank you very much. We will take it up tomorrow.
Thank you, Chair.
Thank you, Chair.
May I remind the members of the tribunal and yourself, Chair, that tomorrow is the 9th of May, and yes, and we requested that Ms. Ngoye kindly be released at 12 o'clock tomorrow. Thank you.